Here it is proceed. I beg to mention item number 7. I have already informed the petitioner.
Then
They have been concerned against counsel for the private respondent, Mr. Dean, and he has transferred to his elder sister-in-law expired.
who has gone?
Mr. Dean and the private counsel for the private respondent number 10. Only pass over the matter for one.
The request of the, when is he coming back?
First of February.
Request of the learned counsel back 6th of February.
Okay.
Respondent number 10. Yes.
I have checked up what has happened here. The affidavit was filed immediately. Subsequently, the judgment of Vijay Madanlal came. At that point of time, perhaps because Delhi High Court had taken a view that value is either definition to where value, if it is any other property loss, that could also have been, that was a view taken by some other high. But subsequently, in view of the law laid down by Vijay Madanlal, so the question remains that whether a part of it can be that.
Let us see section 5.
Yes. May I read? Sure.
If you see section 5,
Sure.
1B, 1A is different. Any person is in possession of any proceeds of the crime. It would not come. That 97 property would not come.
Sure.
Such proceeds of the crime.
Like
These are twin conditions.
Yeah.
Such proceeds of the crime are likely to be concealed, transferred, or which may result in frustrating any proceedings resulting to confiscation of such proceeds of the crime under this chapter. Meaning thereby, these proceeds of the crime are likely to be concealed, transferred, or dealt with in any manner which will result in frustration. And thereby you are not in a position to confiscate.
Yes.
Now, if it is not a proceed of the crime, the question of confiscation does not arise.
Yes.
So, for the 97 property, the proceeds of the crime would not be applicable out here. Now, kindly see the proviso, the second proviso. Provided further that notwithstanding anything contained in the first proviso, any property of any person may be attached under this section if the director or any other person not below the rank of a deputy authorized by him for that purpose has reasons to believe the reasons for such belief to be recorded on the basis of the materials in his possession, that if such property involved in money laundering is not attached, again, that property has to be involved in money laundering,
Yes.
is not attached. Immediately under the chapter, the non-attachment of the property is likely to frustrate any proceedings under the Act. So, these are made specific to a properties. So, for that purpose, in my opinion, subject to what you say, the two properties will remain.
Yeah.
But the third property of 97 cannot remain because it would not be come within the definition of section 3.
I am with your lordship. That cannot be anything.
Yeah. So
Where
the
else?
third, because these are specific,
Yes.
made specific, on the basis of the materials in his possession, that if such property involved in money laundering is not
It has
attached.
to
So
be
the
there.
attachment has to be those properties which are involved in money laundering. Now, what is money laundering? If you see the judgment of justice in this case, why Balaji? You
Yes.
got that now? Last
Yes.
time I gave it to
Yes.
you.
Yeah.
Kindly come to paragraph 97 of the judgment. You got it?
Mine is a different frame. It starts with lordship.
If the main part of section 3, have you got it? You did not get hold of a HSD online?
No, I'm sorry.
Okay, let us do what we- you take this.
Yeah.
I'll take it out.
Lordship. Got it.
Yes, 97.
Yes.
If the main part of section 3 is dissected in with forensic precision, it will be clear that section 3 addresses itself to three things. We may call them the three P, namely person, product or activity, and product. Process or activity and product. Insofar as persons covered by section 3 are concerned, they are those who are directly or indirectly attempt to indulge, or those who knowingly assist, or those who are knowingly a party, or those who are actually involved. Insofar as the process is concerned, the section identifies 6 different activities, namely concealment, possession, acquisition, use, projecting, or claiming as untainted property, any one of which is sufficient to constitute the offense. Insofar as the product is concerned, section 3 identifies proceeds of the crime or the property representing the proceeds of the crime as a product of the proceed, process, or activity. So therefore, for the purpose of the product, 97 property does not come in. So there is no money laundering.
So far as that is
But the other two or any other thing will come within it if it is comes within the ambit of. So under such circumstances, the provisional attachment order, insofar as the 97 property is required to be interfered with. And on the ground that there was the reasons to believe which have been recorded could not have been in view of the law or in view of the definition of section 3 or in view of section 3 or definition of 2U could not have been a reasons to believe. But as regards the other two property, the provisional attachment order may stay.
That is, in fact, like what I had submitted shit. The whole process proceeded primarily on the basis of the judgment of the Delhi High Court, which was not that Delhi High Court judgment, of course, said that if there is any other property of that kind, that can, since later on the law has changed. Now that
No, law has not changed because what has happened is
interpretation has
that might have been a wrong interpretation. But anyways, the interpretation which is given by the Supreme Court now would obviously be an interpretation which exists as on the date when
As
the
on date,
section
yes.
has come in.
as on that is the law, but there is another aspect of the question whether a property prior can be acted. That is the question which has now been referred to. The picture is yet to come. The law has not yet.
No, as regards the earlier property, the definition makes it very clear to the effect that yes, if a proceeds of crime is taken out outside, and then you can attach any other property in India. Now the question is, if that be so, did your reasons which were recorded note that aspect to the matter? Which is not there. As I could see for the reasons just for
This, if I may take a lordship to the act, what has happened here, what the Delhi High Court has done, if we see that you proceeds of the crime means any property, right, or obtained directly or indirectly by any person. Now these three limbs come. As a result of criminal activity related to a scheduled offense, then there is a or. Or the value of such property.
Such property, that property, which have been obtained on the basis of it.
Now, the Delhi High Court gave an interpretation that or the value of such property may include any other property. That is where.
Now, maybe, but I think Delhi High Court judgment has been prior to 2019.
That is, but it has
no, why it is so? Because if you see the third part,
yes,
or where such property is taken or held outside outside the country,
yes,
then the property equivalent to the value held within the country or abroad, which makes it very clear that it is any other property will only come into the picture if it is that property which has been obtained on account of a violation of the schedule offense is taken.
I get your, but a difference was sought to be made in the judgment. The value of the property, of such property, and equivalent in value. Interpretation was given that both have to be given a different meaning. Both have to be given a different meaning. Therefore, at that point of time, they had proceeded.
But whether the Delhi High Court took into consideration such property, the word such property, because the word is such property.
Yes.
When there is a specific indication to such property means a property which has been obtained on account of a violation of a schedule offense.
Just for worship, I'll just read out the Delhi High Court, the few paragraphs.
Which one?
This is Lordship Enforcement Directorate versus Axis Bank. that has
Enforcement
directed it to the Axis Bank. I'm just reading out very slowly. The special legislation against money laundering. This is a judgment by Justice Gauba of 2419. The special legislation against money laundering seeks to enforce the sanction of confiscation initiated by attachment against ill-gotten assets, expecting to ensnare them in a net wider than under most of the existing laws germane to the issue of economic well-being, security and integrity of India as a sovereign state. The expansive definition of the targeted property described as proceeds of crime as given in section 21U is as under, it has been quoted. The above definition may be deconstructed into three parts.
paragraph, which one?
In my it is lordship 103. It starts with proceeds of crime targeted.
Proceed. Yes.
Yes, if I may read, lordship. The special legislation against money laundering seeks to enforce the sanction of confiscation initiated by attachment against ill-gotten assets, expecting to ensnare them in a net wider than under most of the existing laws germane to the issue of economic well-being, security and integrity of India as a separate state. The expansive definition of the targeted property described as proceeds of crime as given in section 21U is as under. Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property, or where the property is taken or held outside the country, then the property equivalent in value held within the country or abroad. The above definition may be deconstructed into three parts. Property derived or obtained directly or indirectly as a result of criminal activity relating to the scheduled offense, or the value of such property as above. If the property is in the nature of the nature first above mentioned has been taken or held abroad, any property equivalent in nature, whether held in India or abroad. Now, lordship will skip one paragraph. Come to the next. It starts with among the three kinds. Among the three kinds.
Kindly come to page 107, paragraph 107.
Yes. In contrast, the second and third kinds of properties mentioned would have above would ordinarily be untainted property that may have been acquired by the suspect legitimately without any connection with the criminal activity or its result. The same, however, are intended to fall in the net because their owner is involved in the proscribed criminality, and the tainted assets held by him are not traceable or cannot be reached, or those found are not sufficient to fully account for the pecuniary advantage thereby gained. This is why, for such untainted properties held in India or abroad to be taken up, the rider put by law insists on equivalence in value. From this perspective, it is essential that for the order of attachment is struck, there must be some assessment as to the value of wrongful gain made by the specified criminal activity, unless it be not possible to put by such stage, given the peculiar features or complexity of the case. The confiscation to be eventually ordered, however, must be restricted to the value of illicit gain from the crime. For the sake of convenience, the properties covered by the second and third category may be referred to as alternative attachable property or deemed tainted property. If I may take the lordship of 109, the inclusive definition of proceeds of crime respecting property of the second above mentioned nature, that is, the value of any such property, gives rise, as it has been done so in these 5 Ps, to potential multi-layered conflict between the person suspected of money laundering, the accused, a third party with whom such accused may have entered into some transaction vis-a-vis the property in question, and the enforcement authority, the state. Since the second of the above species of the proceeds of crime uses the expression such property, the qualifying word being such is revealed that the property referred to here is equivalent to the one indicated by the first kind. The only difference is that it is not the same property. As of the first kind, it is having been picked up from amongst other properties of the accused. The intent of the legislature being that it must be the same of the same value as the former.
So it has to have here also. The Delhi High Court holds that. But in your case, how do you bring the 97?
That
Even if we go by 109 also,
flush.
the Delhi High Court duly takes note of. Yes, such property has to be there. Yes, just for example, a proper person has got a property or made a property or had also, or for that matter, has got money. 1 lakh rupees. Of this 1 lakh rupees, or he has got a particular property, immovable property, in lieu of this criminal activity. Now, this property, he sells it. And upon selling it, he converts it into diamonds. Either the money
Or the
or the time. will come. Therefore, it has to have some relation with
With
that
the-
such property.
Yeah.
And that is what the Delhi High Court also holds. Although this judgment has been distinguished by the Supreme Court in another case, that is in 2021 6 SCC 3258.
flush.
But whatever may be, I don't think the Delhi High Court is wrong in 109. It again refers to such property. But in your case, if you see the reasons which have been recorded,
Flush.
in the reasons which have been recorded, it does not say anything pertaining to or
That's right.
saying it has to come therefore under the third one. Because prior to this, if it was done, if you see the allegations out here, it says that he was joined in the year 1986 and thereafter he has been doing all these illegal activities out there. But it was not there till 2008 or 9. Till 2009, it is not there. So the property which was purchased earlier to that would not may come within the definition of Prevention of Corruption Act or whatever may be. but it would not come within the ambit of the proceeds of the crime. And that aspect have not also been taken. So therefore, the provisional attachment order insofar as the 97 property is bad. But however, in my opinion, the provisional attachment order in respect to the other two properties
That will suffice.
remain. And more so, another very important aspect, you have arrived at this amount of 1.42 crores, taking into account that 58 lakhs.
Yeah, that will come.
If it comes down, then you are duly taken care of with the other two
Other-
properties.
But that has to come.
That will obviously come down. Now, therefore, my question was, if it has to come down, how do I interfere? Because your reasons are cumulative. Can it be severed? Yes, the provisional attachment order is bad. Insofar as that property is concerned, this court can very well help. But whether the reasons on which you have done it should be taken as a whole or can it be severed?
Lordship,
And can this court out here say that no, it should come down by 58 lakhs? And would this court then not be substituting the opinion of the authorities by this court? And if cannot, can this entire provisional attachment order be remain in view of the reasons to believe being wrong? That was my specific question.
Yes. Right.
There was no, otherwise there is no difficulty.
Yes.
From a definition, there is no difficulty. But can you keep on holding that it is 1.42 crores?
Lordship. Now, so far as Lordship provisional attachment is concerned, Lordship will see that once it has been it is again subject to protection under Section 8. Right. Now, when it goes before the adjudicating authority, what happens is the adjudicating authority will do a show cause along with the reasons to plead.
And he can very well show this.
He can, and it may be at that stage that the adjudicating authority will come down upon the pleading. That this portion is not correct. That the adjudicating authority can has got underpaid because
Well, understood. But what do you take care of? How do you take care of when the matter has been placed before this court and it becomes a question of law? Can this court just say that no, you go there?
when there is a question of law, Lordship,
Yeah, the question of law is as
Alternative
regards the
agreement.
definition of section 2(1)(u) as to whether a 97 property can be brought within it.
Lordship, apparently
So I can't relegate them just without saying anything as regards the 97 property in view of that Godrej Sarali judgment.
Yes.
Understood. Normally he should have gone there. He could have very well. On the first day, if the court could have done it.
Yeah.
If I was sitting on the first day, I would have done that. But the question is, if the court did not do that, and heard the man on the question of law which had been addressed, can this court just keep its eyes shut? That you go there?
No.
One thing can be done, however. If I say to that effect that 97 property could not be done, and as the matter is now before the adjudicating authority shall decide all the other aspects, taking specifically the observations made as regards the 97 property.
That-
But I have to hold that the provisional attachment order insofar as the 97 property
that
is
is
wrong.
not
And leaving that aside, because if I set aside this provisional attachment order on the ground that it cannot be shivered, then the entire Section 8 proceedings also goes. Okay, we'll do one thing. We'll hear you on Thursday. Your senior is not there. Because on that day I'll pass the judgment in the court. Pass the judgment in the court. Because I also am of the opinion that the provisional attachment order in respect to those two other properties or whatever other properties will remain.
That-
Because this will automatically come down.
Yeah.
If it automatically come down, would it require a fresh provisional attachment order, or that can be very well taken note of by the adjudicating authority? Because it is a confirmation of the provisional attachment order. That is why the mandate is within 30 days you are to file it. So it is temporary, which is now would attain finality. And in view of the judgment in Vijay Madanla, you cannot sell off this property till the final decision outcome of the trial. That you are protected, they are protected. Only that there is no use of state. Now, have you sold those properties in view of the stay? You're sure?
fact that my date was order, not
There's an order, na?
Yeah.
Very good. Check. But what remains if you have an order to that effect, the provisional attachment order is subsisting.
rest of
Uh-huh.
rest of the property.
Hello? Okay, I'll take it up on Thursday. No, it's okay. I've heard you. It's only on that.
Yeah.
Because you say, that day, you say, his submission is it cannot be shivered. No, his submission. My opinion is it can be shivered. And I have also heard you on that. Now, I think an opportunity should be given to him
Definitely.
because of that, when I have point, because that point I have raised on the last occasion. Otherwise, 97 property cannot come within it. And in fact, the Delhi High Court judgment is also on that. Anyway, and in fact, I think the judgment of the Punjab and Haryana makes it very clear.
Timagak,
Uh, yeah, this Judge Timaga makes it very clear on this issue.
in fact,
But therefore,
both
I
these judgments are contrary to each
which
other
one?
on the point hardship.
No, in that property also, in Delhi High Court also categorically says that, and Simagar also. Therefore, I went and further to look into these Vijay Madan Lal and all these cases, where it has now been made very clear that it has to have a proceeds of the kind. There has to be a strict and a strict interpretation.
Penal.
And the Supreme Court says it is a strict interpretation. We can't divert. So therefore, I think the best option is there. We'll have it on Monday, Thursday. Or do you want to do it on your day when you are there? That will be on Thursday would be fair.
Monday or
You
Tuesday.
can have it on 6th. You're there. It's Tuesday.
Yes,
I'll deliver the judgment in the court itself. This court have heard the learned counsel, Mr. R.K. Chaudhary. He had completed his argument. For the purpose of reply, this court fixes the matter again on 6th of February to be listed at the top.
this is
Which one?
hardship. Why?
Oh, yeah.
Okay.
Yes.
But yeah, but that matter the final assessment has been made by the eviction, my lord. During that point of time, my lord, they have collected the bill was my lord effective in nature, their bill itself. So we finish this in order.
Then final assessment bill, you file an appeal.
No, my lord, that time we have not filed.
Then what did you do?
My lord, we have approached in earlier two also, my lord, we have approached for the same bill, my lord.
Hmm.
Initially, it was been raised to 39 lakhs, my lord, that we have finished, my lord. It was found in course of hearing, my lord, by the honorable court, my lord, but no opportunity was given to me, my lord.
Hmm.
Then I get subjected to the writ petition, the honorable court directed to appear, my lord, had to give opportunity. Accordingly, we went there and submitted, my lord, our reply, my lord. Then, my lord, it subjected a in order.
Then
Then, my lord, in order they are asking now, my lord, for 10 lakhs.
have you paid that amount?
No, we have not paid, my lord, because
Well,
5
is there any interest and penalty to be paid if you don't pay it?
Sir, there is a surcharge, your lordship. Is that
What is the illegality?
legality is that, my lord, the meter itself was a defective one. They have collected the bill in the name of defective meter. Suddenly they came, my lord, and they found some part of that broken, my lord. I have given color photographs also. It is well protected, my lord. It cannot be tempered under any circumstance.
The meter was okay, but only the outside portion was broken.
Outside portion was some broken, my lord. Lordship, kindly have a look the photograph I have given, my lord. Then your lordship would see, my lord.
Yeah. Then
Then, my lord, lordship will see the photograph that page 45,
Hmm.
46, my lord. It was intact and sealed, my lord. Lordship has seen the small bottle.
Hmm.
Then, my lord, they said, my lord, it was the outside the campus, my lord, which is 32 feet away from my campus. That is meaning thereby in the roadside, my lord.
why
Was
did
there.
you keep it in the roadside?
Because, my lord, they themselves installed it.
They themselves won't install it unless you place it here.
My
You
lord,
don't give a place. Isn't it the regulation out there?
my lord.
it is, your lordship. And in fact, even if it is outside, is my
It is you are responsible for
Yes,
that.
it says that.
You have given who has asked for the electricity?
I asked for the
You want the
electricity.
electricity or not? They
electric-
will put it on a place where you provide it. You have provided that place 32 feet or 32 meters away.
And that, my lord,
Last time you wanted to withdraw, I suppose, this
Yes,
matter,
no,
na?
lordship has given
Huh?
me one judgment, my lord. Lordship has given me one judgment, my lord. I have gone through it, my lord. It is relating to
I
my lord.
remember.
It
Huh?
is relating to my lord. Tender matter, my
Which matter?
lordship has given one judgment, my lord. It's there in my
Which one?
some Rajasthan or
Lordship
something.
had that.
Oh, that one.
Ah,
Yes.
it is
That is not a 10. There are three aspects.
There are three aspects. Sir.
One was the matter as to why this court should.
Yes,
Yes, you
yes, my
were.
lord. 104
I
and
remember.
105,
I have a
my
copy here.
Yeah, the
104
judgment
and
of Justice
105.
Gavai. Where is that?
I have a copy. Here.
104 and 105, my lord.
Yeah, I give it to you.
Yes, my lord. I have gone
Then
through it, my lord. But it subject matter differ from me, my lord.
subject matter is not different. Subject matter, there are 3 points which have been raised out there. One of the points out there is when the matter pertaining to electricity is there, why should this the self-contained court?
In fact, your lordship, the
Yes.
finding in this judgment, where the Honorable Apex Court has said that if the act is a complete code in itself,
Hmm,
then the writ court may not interfere.
hmm.
In fact, if it is read along with the ratio
You
Sitaram
said I
Sitaram,
have not gone into the various that judgment and as such thought time and as such I fixed this matter and made it a matter of importance.
paragraph 140, perhaps the
104 and 105.
one makes it very clear.
Paragraph 136. Paragraph 136.
136.
Here.
When the High Court was not entertaining the Constitution bench in Toronto has held that the Electricity Act, the exhaustive code on all matters concerning electricity. Under the Electricity Act, all issues dealing with the electricity have to be considered by the authorities constituted as held by the Constitution. State electric officials, the learned poets, have ample powers to adjudicate in the matters with regard to the electricity. Not only that, these tribunals are consisting of experts having past experience with the field. In essence, we find that the High Court erred in directly entertaining and adequate alternative remedy of approaching state electricity commission.
Yeah, my lord, what happened during that time, my during that time, my lord, I filed two writ petitions. That writ petition was certain, my lord. My learned friend was also there from not he the one, but other counsel appeared represented, and the honorable court disposed of. But at this belated stage, my lord, I cannot approach for the limitation part. And my lord,
Limitation, don't worry, I give you 30
my
days.
lord, even though my lord, 50%, my lord,
That
you
50%, my lord, that will create me a trouble.
Okay, we will entertain the subject to deposit of 50%.
But at
The
least,
interim orders is only until further orders. Huh?
my lord,
So, till then, so this interim order will modify it to 100%. Then we'll constitute. Give a bank guarantee by tomorrow.
tomorrow, my
Week.
lord,
I give you a week's time. Give a bank guarantee. For then the interim order will be there, and that will be subject. The moment I dismiss it, you will get the bank memo. You'll be happy with.
my lord, may I make one submission, my lord? Instead of bank guarantee, I'll give the bond, my lord.
No bond.
My
No
lord, I'm
bond
the
business.
honest businessman, my lord.
We don't go by
At
bonds.
least,
Bonds are not there.
at least, lordship, me consider, my lord,
No,
the length of,
there's nothing bond. Give the amount in bank guarantee, then we'll extend.
Very-
Otherwise, disconnect.
no, my lord, they had disconnected, then honorable court directed to restore my,
So we'll disconnect it.
no,
You can't be. This,
or
first of
lordship
all, the
can give me, my
repetition
lord, a
cannot
week
be.
time, my lord, regarding the bank guarantee.
Show me any jurisdictional point out here. What is the jurisdictional?
My lord, yeah, my lord, what happened when they
It
have,
is a simple case. There was a notice issued. There was a what you call an assessment made. A provisional assessment was made. Subsequently, you were heard, and there was a thereafter the final assessment was made, and the 10 lakh amount has been given. Against that, an appeal lies. What is wrong with it?
my lord, actually what happened, my lord, during initial stage, my lord, by filing their own note, my lord, they have disconnected without giving me notice, my lord. Their own act, their own law says, my lord, it has to be given 24 hours notice.
Why should I look into that? Now you have the reconnection out there.
So, my lord, may I pray one thing, my lord? If lordship are asking me 50% can guarantee, my
100%.
lord,
Not 50%. 50% is for the tribunal. This court doesn't go by, and that's a bank guarantee 7 days, and then only they will decide if it goes against you. You take quick disposal. We become like Singapore. Yes,
my lord, for bank guarantee and anything, my lord, I need some time, my lord, to take it.
absolutely no. This is a case for dismissal, outright dismissal.
1030.
You want the only thing I can help you is give you 30 days to go and file an appeal. That's all.
30 days, I can file a bill, my lord. Only lordship kindly give me, my lord, exemption of the 50%, my
Why
lord.
should I? Absolutely no. I don't find any good grounds for entertaining the petition. Tell me,
All lordship give me, my lord, 1 day time.
for what?
Only 1 day
No,
time.
no, that I gave you that day. That is why I fixed it today.
Yes, lordship has
Well,
fixed it, my lord.
Gave you 18 days for that.
Lordship has given correct, my lord.
Yeah,
But
then
now, my
enough.
lord, the for bank guarantee is
Anyway,
concerned, my
Okay.
lordship
Heard
only.
Mr. JL for Bhavia to learn it counsel.
All lordship give me, my lord, not 30 days, my lord. Some other-
Mr. K.P. Pathak, the learned counsel appearing on
Some-
behalf of the state.
That one number is 225.
The instant writ petition has been filed
All of you
challenging.
give me, my lord, 30 days time, my lord, I'll prepare, I'll refer appeal, my.
That is what I was going to do. Don't worry. The instant writ petition has been filed for challenging the order dated 2/6/2017, along with the final order of assessment of bill issued by the respondent number 5, amounting to rupees 10,96,178, and for other consequential direction. So the record reveals that the petitioner number 1 herein is a partnership firm and running a hotel in the name and style of Barak Residence, situated at Hattigaon Road, Dispur, Guwahati 781006. On 11/5/2016 at 3 p.m., the respondent number 5 disconnected the power supply to the petition. On the very day, the respondent number 5 also sent a communication to the petitioner stating that the petitioner was involved directly or indirectly in malpractice stating inter alia that the petitioner, that the evidence revealed that the petitioner number 1 was directly or indirectly involved in the act of malpractice, for which the petitioner's connection was disconnected on 11/5/2016. Further to that, an assessment bill, an initial assessment bill, was submitted to the petition, amounting to rupees 39,10,159. It may be relevant herein to mention that this initial assessment bill has been issued in terms with section 126(1) of the Electricity Act 2003. Na?
Yes.
The petitioner thereupon challenged the said communication dated 11/5/2016 as well as the disconnection notice, as well as the disconnection, by filing a writ petition which was registered and numbered as WPC number 2960/2016. Discovered by an order dated 17/5/2016, issued notice of motion, and in the interim, liberty was given to the petitioner to apply for fresh meter for their hotel and make necessary payment of resumption of the power supply. It was also mentioned that if such application was filed by the petitioner and the dues for the new meter is deposited, the respondents would restore the power supply to the hotel premises. The record further reveals that a new meter was installed on the basis of the interim order passed by the court. Subsequent thereto, the petitioner was issued notice in terms with section 126(3) of the Electricity Act 2003, intimating about the hearing in respect to the provisional assessment bill which was submitted to the petitioner, and asking the petitioner to file any objection if so advised. The petitioner, instead of submitting any objection, intimated the assessing officer that the matter was sub judice before the court, and as such to adjourn the hearing in the matter till the final decision of the court. Thereupon, on 16/6/2016, in view of the fact that there was no objection filed, the provisional assessment bill was made final, and the petitioner was directed to pay the said amount of rupees 39,10,159. It was also indicated by the order dated, by the communication dated 16/6/2016, that the petitioner may prepare an appeal in terms with section 127 of the Indian Electricity Act 2003. The petitioner thereupon filed another petition before the court, which was registered and numbered as WPT number 3765/2016. The said petition was disposed of by an order dated 23/6/2016, observing inter alia that the said final assessment order was passed, bill was issued, without taking into consideration the objections so filed by the petitioner. Under such circumstances, this court directed the petitioner to file their objections on or before 8/7/2016. And if it was filed within the due time, the competent authority was directed to consider the objection and then finalize the provisional bill after affording a hearing to the consumer. It was further mentioned that the final assessment bill, which was impugned in the said proceeding, would be subject to the outcome of the said de novo proceeding directed to be initiated. Thereupon, the petitioner submitted an objection before a detailed objection before the assessing officer on 4/7/2016. There are the record further shows that on 2/6/2017, the assessing officer passed the final assessment bill amounting to rupees 10,96,178 and directed the petitioner to pay the assessment bill within the due date. The petitioner has challenged this assessment bill as well as the communication dated 2/6/2017 by way of the present writ petition. I've heard the learned counsel is appearing on behalf of the petitioner as well as the respondent APDCL. Upon hearing the have filed the instant writ petition. Filed the instant writ petition on 9/6/2017. The record reveals that on 21/6/2017, the respondent APDCL authority, this court had directed the respondent APDCL authorities not to disconnect or not to disrupt the electricity connection of the petitioner. Thereupon, by another order dated 12/7/2017, notice was issued and the interim order was which was passed earlier, was directed to continue. I've heard the learned counsel is appearing on behalf of the petitioner as well as the respondent APDCL. Upon hearing the learned counsel and have duly taken note of their submissions, the submissions which have been made by the learned counsel for the petitioner is not on the question of any jurisdictional issue touching on the authority of the respondent number 5 to issue the impugn communication dated 2/7/2017, 2/6/2017, as well as the provisional bill, the final bill of final assessment bill. The submissions have been made to the effect that the meter in question might have been broken. The cover of the meter in question might have been broken due to earthquake or for other reasons. And also to the effect that when the inspection was carried out on 3/2/2016, the breakage of the meter cover and the seals were not detected at that point of time. It was therefore submitted that on the basis of the meter cover of the meter being broken, the final assessment bill ought not to have been made. in the manner in which it has been done. The learned counsel appearing on behalf of the petitioner further had drawn the attention to the photographs pertaining to the said meter in question. And further submitted that the petitioner had no hand in the breakage of the cover of the meter. The above submissions in the opinion of this court are not submissions on touching on any law point, or for that matter, touching on the question of jurisdiction. At this place, this court also finds it relevant to take note of that Section 127 of the Indian Electricity Act 2003 is a special code by itself, providing the various avenues, providing is a special code by itself, providing avenues, providing remedies against the final assessment bill. It is also relevant to take note of that the appellate authority, that is
It's called the appellate authority.
the appellate authority of the APDC.
Under section 127.
Is also relevant to take note that the appellate authority under section 127 consists of members who are experts in the field, and these questions of facts can be very well adjudicated by them, very well taken note of, very well taken, be decided by them, adjudicated by them. In fact, this court finds it relevant to refer to a recent judgment of the Supreme Court in the case of Jaipur Vidyut Vitran Nigam Limited versus MB Power bracket Madhya Pradesh Limited, reported in 2024 SCC Online SC 26. Wherein at paragraph number 136, the Supreme Court made it clear, had categorically observed that the Electricity Act, Indian Electricity Act 2003 is an exhaustive code on all matters concerning electricity. It was further observed that the State Electricity Commission and the learned ATTEL has ample powers to adjudicate in matters with regard to electricity. The Supreme Court observed in the said judgment that the jurisdictional High Court was not justified in entertaining the writ petition. Paragraph 136 and 137 of the said judgment being relevant is reproduced herein under. This court is also not unmindful of the fact that the instant writ petition has been pending for the last 6 years. But the fact that the dispute in question relates to adjudication of factual matters as to who would be responsible in the breakage of the cover, and as to whether the petitioner would be responsible in the breakage of the cover.
What can they happen? What if it is that take my defective number defective replaced page 51 for
Cannot be adjudicated by this court under Article 2 to 6 of the Constitution. More so when there has been no legal points urged. Under such circumstances, this court is not inclined to entertain the writ petition on the ground of availability of an alternative and efficacious remedy. This court have also taken note of that be that as it may, this court, however, finds it relevant to observe that the petitioner have immediately but have had approached this court against the final assessment bill and the order dated 2/6/2017 on 9/6/2017, and the matter has been pending since then. A perusal of Section 127 of the Indian Electricity Act 2003 also stipulates a period of limitation that is 30 days. Under such circumstances, it is the opinion of this court that if the petitioner is advised to approach to file an appeal, is advised to take recourse to Section 127 of the Indian Electricity Act 2003 against the impugned order dated 2/6/2017 and the final assessment bill, the period during which the instant writ petition has been pending, that is from 9/6/2017 till date, shall be excluded while computing the period of limitation. With the above observations and directions, the instant petition therefore stands disposed.
maybe keeping me one liberty, man, that I'll approach the certificate copy along with the copy of the writ petition, because all the materials are the writ. That was the while preparing
Why?
while preparing the appeal.
Appeal is in a particular format.
Is in a particular.
You want to use some document, file application, why should I give liberty? I don't give you. I've given you enough.
Process has given time, but not within a period of
You file whenever you feel, right? I have only excluded from 9/6/2017 till date.
till that.
So
30 days
that period, yeah. So you have to file because earlier you have already lost 7 days. So from today you have 23 days. Oh,
Lord, you have directed me to file an additional affidavit in record the document filed by the respondent of 3 and 5. I will be getting the affidavit today itself. What you
why
take it on-
every time you are taking?
Well,
Okay,
what
we
you
give
take
you
it-
time, but cost.
Oh, Lord.
No.
Let it be on
No,
second, my lord.
no. This is a case of every time you have been asking you to file that.
These holidays, my lord, in between, my lord, there are some
What?
holidays in between that.
No, that is why.
holidays, my lord, that cannot be.
Holiday from 2012, 2023 till
Just
date,
I
it
have
is a
sent it, my
holiday.
lord, but in the meantime, these 3-4 holidays has come into that,
So,
nothing cannot be done. That's
the holiday gives you more
I'll file
time,
it on-
otherwise you
on
are a
fast
busy
file.
counsel.
I'll file it on first, let come on second. Because by 2 o'clock, I'll get the affidavit.
See, on 22/1/2000, at the
One chance,
request
my
of so matter sent adjourned to the, you
One
asked
chance.
this matter to be
One
listed.
chance, my lord. Let it be on second, my lord, I will file it by first.
Who is appearing for response number 5? We are only concerned with 5 and 6, na?
5 and 3.
Private thing.
I'll be in
Who
the.
is appearing for 5 and 6? Huh?
I have filed mine, Lord.
Who is 5? You are 5.
He has not filed.
I don't think someone has appeared for 3. There is no activity, there is no name to the house.
He has not
Who got more marks than you? You had allegations against 2 persons, huh?
Initially, the
Which
allegation
shows
is
as
against
to whether the response number 3 and 5 had the work experience for house service connection. That these documents would definitely be available taking into account the mandate of students. So 3 and 5. So 3 and 5, who is appearing for 5? You.
I am.
So you have the
He has filed.
experience.
Yeah, I have some record.
You file affidavit. Very well.
Record,
And what about 3? He doesn't want, in spite of receiving notice, he has not appeared, so we cancel it, give it to him.
let me get the record, my lord. First of all, on first I'll file my affidavit, my lord.
No, we
second,
set aside 3. Give it to her. She will number 4, na?
If someone goes, he will be in the
So, so 3 is okay. He is not interested.
let me find my record, that particular record.
Who has filed this affidavit?
I have filed, Doctor. After he gave me the paper,
Affidavit by response number 5. Let us see what he has.
but
We
one-
can throw out the response number 5, then only we need not go to 3. You have the experience.
Yes.
Where is the experience?
annexer email.
Annexer A,
Email. It's 64,
A,
65, 67. It's
no.
more experience.
First of all, Mr. Ahmed, kindly make these things clear. Your page number is 138, not 64. Okay, now you had the AR with the project director, project implementation, JICA. This is 7/9/2020. JICA is Kolkata Municipal Corp. You are Furnace Fabrica.
no, he's not.
Who are you? Who is response number 5?
Tajuddin
Tajuddin.
Tajuddin Ahmed of Morigaon.
Then, what does this Furnace Fabrica have to do anything? And successfully executed by Tajuddin Ahmed Guwahati.
Yes. I have a issue there, Doctor. I'll just point out. It's consistent.
Tajuddin Ahmed.
It is Tajuddin Ahmed Morigaon.
And this one, this other one, Muslim Gaon,
Calcutta has given
Morigaon.
a certificate for Tajuddin Ahmed Guwahati. They are 2 different entities.
And what about this page 137 or page 63 of his affidavit? 63 of his affidavit page, actual
Yes,
page is 137.
Yes, Doctor. This is some
2000.
project JICA. JICA has given, you are hereby requested money performance security for this.
This is Tajuddin Morigaon.
This is Tajuddin Morigaon.
And Tajuddin Guwahati and Morigaon are different.
Obviously, not two
Next
different
page,
entities. Even
number
in the
64 one, they say that Fabrica is a subcontract and actually executed. Tajuddin has executed of Guwahati has executed in Calcutta.
Tajuddin Guwahati has
So
executed.
Guwahati is same. Tajuddin
That-
Guwahati.
No, that we do
That I
not.
have seen that same person. They say this is the same person.
How do you know?
How
Did
do
you
know?
look into that?
And Lordship, I will also So,
Hmm.
I think it's there.
65 another
My-
another certificate of
Because
It
you
might-
see his registration certificate is Tajuddin Mori Muslim Gaon house number so and so. He has no address in Guwahati.
Yes, sir.
it is Tajuddin one.
Huh?
Next page, my lord, 65. There is
65.
another household.
What is this? 62. 65.
Right.
This is to certify the working of so and so. Santi awarded to so and so and successfully executed by Tajuddin. How is Tajuddin connected
Morigaon
with
division,
Santi?
Morigaon division is he is constantly saying that
No,
Tajuddin one.
Mr. Bora, how is, what do you require? Execution
Yes,
or
right.
awarding of contract?
Execution of the more than 500 connections.
More than 500 connections.
Completion certificate you have to give
Let us see the terms of the contract.
page 30. Serial number page 32 2.2.
Work experience to the experience of working as main contractor or subcontractor
Or
of
subcontractor.
providing water, house connection, 500.
500 minimum 500 they have to.
How do you know that he is subcontractor? He is not the main contractor. Awarded to somebody else.
He has given this document. He has the minimum is 500. So there are other documents to show that there he has done many other contract work with active
Where?
500. Because what you will find
There's a different contract.
different contract that you will find page number 65. There is 800 also in Titapur it is. That is
Understood, but this
from-
is by awarded to Santi Enterprise.
Executed.
Executed different thing.
this is there is a subcontract.
He is a subcontractor.
Next page is
This
66.
is also again same.
60. Next is same.
The subcontract.
Same.
Both are subcontract.
Next is 875 but the JICA. That is the respondent number 2 is there.
This may have relevance.
Then my lord,
This was given when? Now tell
this
me,
is dated 29/5.
when was the last date of submission of tender document? Last date of 30/5/2023.
Last
This
date of
was
the
given on
31st.
29/5.
This is 29/5.
But if you see this particular document, this is in relation to the other one, no? Page 130, page 50. The JICA one.
This is another package.
That's the same one.
Yes.
This is the 2000 house connection.
12B.
It's the same connection where 12B. That is it.
This is 12 1.
No, same.
12B1. 12B1 is 12.
No. Kindly come to page 137 and 141. It is one and the same. One is the contract given and the other is the what he has done.
Yes, it's one and
Page number 27 of the writ petition, it is the contract package number 12B1. 12B1.
Where?
Number 27.
Where?
Page 27.
Of the writ petition.
Not of the writ petition. Contract package number 12B1.
No, not this. I'm not on
This
this.
is the main
Here.
This is the main contract.
This is like the contract which was given
with the
On 7/9/2022.
Yes, that is package
That
number
is for 12B.
12B. This is different.
Understood? No, I'm saying this 12B is the same with this. This is the certificate. 29/5/2023 is the certificate.
Yes, 2000 household. 12B. Package is 12. Same thing.
he has completed
Yes,
877. 877 out of 2000.
Within 9 months. You are supposed to complete it within 9 months. Isn't it? And response number 5C is already not repairing.
I don't think they have filed any wakalat.
So they have been served.
They have been served.
So under sir, they are not interested.
Maybe, my lord. But I have the document that is.
But you have not brought on record those documents.
That's why, my lord.
So
All
we
the time, my
shall
lord,
not
this is-
take into consideration those. Then you file appeal while it is being set aside. And then
What you will give me 1 day time, my lord.
what one day? I have given
Oh.
you so much of time.
Or today itself I can file my affidavit.
So look, fine.
It says you filed by the petitioner. So what? Additionally, we filed by the petitioner. See, so what the
WhatsApp. You have got it.
He
Yes,
asked my,
sir.
asked my
Nowadays
junior,
we are into e-filing.
what
he asked my junior to give him my WhatsApp, so she gave it.
Then
so around out of
I filed my additional based on the documents which he provided.
where is your additional affidavit? That is not on record.
It's on record. Not.
No, it's not on. When did you file it?
18-1, 18-1.
18/1/2023.
Yes, 24.
24.
Just before the
it is
respondent filed.
on record.
Same day.
You
Same day. Same day.
Same day. Same day.
I think that's the confusion in the page number. Minus 67. Running page minus
Running page is not been
67. This comes after mine.
So have you served a copy?
Who?
The petitioner. Your affidavit.
No, my lord. I will get it by 2
He's
o'clock.
he's getting to
By today, 2 o'clock.
You serve a copy.
Good.
We do one thing, we'll have it on 13 February.
I thought we figure out that.
Huh?
Let it be early, my lord. Let it be on 6th.
6th of February.
6th February.
Six, I've got so many matters.
Then, my lord, let it be on 2nd, my lord. 2nd February. I'll file it on 1st.
Fantastic. I'll have it on 2nd, but subject to a cost of 50,000.
But
Because this has to be done. Then this court will have to sit after 4:15.
then, my
For your
lord,
matter.
any day, my lord. I am ready
Then-
any day.
Let's do it on the 2nd. I'm
Let be any day, my lord. I am ready.
I'll take it up after 4:30.
Not,
But
not,
subject
not
to a
till
cost
fixed
of
date, I
50,000.
will file on 1st. Any day.
The learned counsel standing counsel appearing for the Jalbad have not filed the affidavit in opposition till date. What affidavit do you want to file?
I'll bring the record of the
those,
document filed by the
documents on
respondent.
record.
I have not filed the affidavit in affidavit in terms with the order dated
2012. I'm PTP is ready, my lord. That will come on by 2 o'clock.
He only has particular record.
Yes,
have
sir.
not filed the affidavit in terms with the order dated 30/11/2023. In spite, there has been 2 additional chances have been granted on 20/12/2023 and 22/1/2024. However, for the end of justice, this court grants another 7 days time to the petitioner, to the respondent number 2 to file the affidavit as directed, failing which this court would be constrained to impose a cost of 50,000 rupees at cost. Let this matter be listed again on 15th of February 2024. The petitioner in the meantime would be at liberty to file their reply. The respondent number 5 would also be at liberty to file the reply against the additional affidavit so filed by the
I can speak. Yeah, 2015 में पूछा।
Mr. A. Rohit, the learned counsel appearing on behalf of the petitioner, submits that the petition has become infructuous due to during the period has become infructuous. Taking into account the above, the instant petition therefore stands closed as it has become infructuous.
I know what he
private 7 method.
kindly see the page 13 in my affidavit in opposition.
Detailedly. This is of 2013.
Yes, but the finding, they are finding, yeah.
Huh?
Finding is there. Actually.
This has been challenged.
It is 100%. It's 100%.
It's not
Okay. 14/8/2013.
This is the one which is under challenge. Yes, report number 7.
my lord. State level committee is not here is the party.
Which one? Which affidavit? Filed on?
My lord, at page 13 in 13
Which affidavit?
my affidavit in opposition. My
When did you file?
filed by the respondent number 7.
When?
15.
2015. Yes.
My
Okay.
lord, in this order at page 2, in order to further ascertain the genuineness of claim and
Which
counter
paragraph?
claim,
Which paragraph?
paragraph, my lord, at page 2, first paragraph, page 14,
Paragraph 4.
oh,
Huh?
paragraph 8,
Yes.
page 14.
In order to further ascertain the genuineness of claims and counterclaim, a group of officers consisting of members of SLSC, I director, WPT, and VC director, welfare of scheduled caste, and director, ART and SC were asked to make spot verification and submit report. Height order nung.
Yes, I have read it. What is there?
Then they have declared the respondent 7 is a scheduled caste. He belongs to scheduled caste.
What is the basis?
Spot verification was conducted and local people were asked.
The local people will know.
And
The local people
and circle officer also conducted spot verification.
is the circle of the
They
circle
had
officer
committee
has
made spot
submitted a
verification on
report
interested
with
cross.
the council the 4/1/2024. The learned council could have drawn the attention for 150 to the that is prior to that, yes, on 26/9/2006, the instructions which were placed on this that day was not clear as to how the Patra number 25 became Patra number 37. The Deputy Executive Commissioner Borpata was also asked to clarify as to how Patra number 37, the petitioner's father had been Harip Patra, which however is different from the person whose name appears in Patra 25. Borok Koibotra. A perusal of the said instructions revealed that the name of Borok Koibotra is in Patra number 25 it is, but the circle officer Borpata dated Iman reported that as per the Jamabandi available in the office of the circle officer, Borpata, no name is recorded as Harophonda or Harokototo in the plan covered by Dak. However, in the plan covered by number 20 of Dak, there is the name of Harophonda of Hanikta. It was further mentioned that on 22/9/2023, the petitioner had submitted another affidavit claiming that he is the grandson of late Harophon Das and both persons are one and the same. It was further mentioned in the same instruction that other than the studied affidavit, there is no other evidence to connect Harophon Koibotra with Harophon Das.
My lord, Horok Koibotra in a Pattanam over Jamabandi of 1923 to 28. Here is Horok Koibotra, son of Manik. But later, then a title was changed.
How?
Surname was the title was changed. To
Except
Das.
your affidavit, there is nothing on record. You have only filed it.
My lord,
And Mr. Soroni, on the last occasion, I asked you to file an additional affidavit.
Fine,
File
I
that.
filed on 8/1/2024.
Yes, you have a copy of it. It is gazetted notification of 15th of May 1991. Finally come to page 94, running page. Provided that while making an inquiry following aspects in addition to other relevant matters that taken into consideration, the caste of a person does not change by marriage. The offerings of the couple who, where one of the spouses belongs to SC, does not automatically become SC, excepting brought up in social customs and environment of the ST community and been accepted as such by the community. Where the surname, now most pertinent, where the surname of the person is not same as or usually used by ST community, verification of the surname of the ancestors will be necessary. Now, have you done that? Das is okay. Middle class it may be.
Yeah.
But what about him? You are what?
Das.
Haramohan?
Harmohan Das and Harmohan Koiburtu.
You are the Das.
Talukdar.
Talukdar. Talukdar, how does it become? Talukdar is not a surname for ST. Normally.
As per my instruction, Lordship, here they have submitted affidavit.
Who?
Procedural. That's point number 7.
So, his affidavit would be enough.
It is stated here that
Anybody can file an affidavit that I am a ST.
no, Lordship, it have stated that his father, my grandfather, was my Horo Koiburtu and Harmohan Das. Was
Whether his affidavit is enough. Because you see, there are a lot of contradictions. He has shown a particular patta where the name is Horomohan Horo Koiburtu. But that patta does not correspond to patta number 37, where Horomohan Das is given. Okay? So that was the basis on which this court made an inquiry. At last, the circle officer or your district commissioner has come up with a finding. Then look here, we don't have anything except that particular document. That your affidavit, which you are holding. Huh? But can
Hello.
that be the basis?
there were some other documents and spot verification of other persons.
What verification? Whom did you consult?
The villagers.
Whom? There must be recording of their statement. Or just making it that we have made a spot verification, would it suffice?
Section of people, including representative.
Only that is
Yes. Would that suffice? Whom did they ask? Did they ask the people from the locality? Anybody can put it. Anybody can put that. Who had gone and made the spot verification? Are you saying that all the 3 persons who signed that order have gone there?
further court. As per this
Yeah.
order, but the order I am holding.
Who had the committee made spot verification? All these people who have gone there. Who is the committee? The committee of the director
Direct-
so and so made spot verification. So let us see that spot verification. You must be having.
But
You'll have it, obviously.
that I don't have right now.
Because the matter has been pending since 2013. So you
Now I-
having it.
Now I don't have a
Okay, you produce that. Let us see what spot verification you have done and whom have you asked. Because merely by staying in spot verification, you can't make this person of the SC. Because otherwise, all the other things does not. And as to whether that very person, Horo Koiburtu, was a resident of that place where you have made the spot verification. Because he has not been able to connect the land documents of his with Horo Koiburtu. Isn't it?
Smile.
He has not been able to connect.
And even when applies for the certificate, he has to declare which land is now he might have decided. In that land, he has shown different land, with the external land. In their application.
In the application.
The land is different, might have.
So let us get the records, find out what are there, what is the basis of which Mr. C.R. Sharma.
teacher.
C. Sharma appearing on behalf of the deputy
No, Lord, I've got
for social
justice and or
social justice and empowerment is directed to produce the records pertaining to the spot verification so conducted on 9th of July 2013, which was made the basis upon which the impugned order dated 14/8/2013 was passed. So, along with the same, the records relating to the application so filed by the petition by respondent number 7 for the scheduled caste certificate we also placed before this court. When 13
Dr.
13 is the matter again on 13th of February 2024.
Valid.
Item 4. Yes, what is this?
Lordship, they then were requisite lordship for construction of forest of their
Petitioner's land were acquired.
lordship requisition first, which then acquisition process was
They've got the money.
to some extent the tip, but and the entire amount of for the
What is this entire? As per the awarded amount, have you received?
no requisition. Acquired amount they have not yet got calculated.
Have they acquired?
Press already there are other proceedings which was executed that was that thereafter press other was executed but not able.
So as of now, who are you in possession of the land?
For the land taken long back construction of forest division.
Have they constructed of
Yes, sir. The office is part of the
what do they say? The affidavit?
Deputy Commissioner Lordship filed affidavit indicated the case that land were execution Lordship.
Respond number 4.
Yes.
What does it say? The deponent admits the fact that RT allocates so for the
Balance amount was not
admitted
paid.
the fact that rigidity requiring even with the package only to tap up when on balance upon the fee. But the forest department did not deposit the state tax. Thereafter, as per the therefore, the not estimated at that according to the So as of now, there is no land acquisition proceeding. Who is the respond number 8?
8 is forest.
What does it say?
But their numbers is not mentioned in that order. Except that the other that numbers are there. 5,07,000
Two?
to the
That I know.
that amount.
So as of now, who is in possession of the land?
Forest, but forest,
Yes, forest, no forest,
forest is saying not the Department of Revenue, but paragraph
whatever
11
may be.
dot-
Yes, what is this? No revenue department, no forest department. What to do? As of now, what do you want, madam?
at the rate of present rate of the
So there has to be a de novo proceeding.
Sure.
Without the de novo proceedings, they cannot.
Sure. Deputy Commissioner active there was a reassessment. They failed to, the forest department failed to because
So how can the forest department now hold this land?
exactly.
So we have to direct the forest department to clear this land, give it to them within 30 days. Third, Ms. R. H. Chaudhary, the learned R. Chaudhary, the learned counsel appearing on behalf of appearing on behalf of the
On the form, the deputy commissioner.
founded number.
Oh,
Correct?
the deputy commissioner.
Respondent number 4, whose none appears on behalf of the revenue department of the government of Assam, as well as also for the forest department of the government of Assam on call. It is also pertinent to mention that the names of the it's also pertinent to note that in the cause list, the names of the standing counsel for forest and finance have been duly indicated. The case of the petitioner herein is that the subdivisional officer Karimganj, bracket land acquisition branch, had initiated steps for acquisition of 15 bighas, 17 kothas, 11 chotok of land, which included the land of the petitioner, for construction of the departmental building of the forest officer at Karimganj. In the said communication, Annexure A is the communication by which the requisition proceeding was initiated. Your name is there?
The that numbers are there.
The name of the owners of the land?
Oh, but that
Prabhudanda Datta.
British name are there. Prabhudananda is second.
Huh?
British name are there. Abdul Bakur.
How will you know that Abdul Noor is
We have
connected with you?
one representative for the
No, 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 no. How will you know if you have not made any statement out here that you are connected with any of the persons whose names are there?
that number or that number are
Where is it? No, it's the Khatyan enclosed out here. Then
we have mentioned the area allotment in para 2. The dark number, Satya number, area.
Understood, but these Khatyan numbers are not before this court. Would it be proper on the part of this court to direct the forest department to hand over the possession of the land to you on the basis of a writ petition where there is not a single statement that you are connected with those persons, or showing that prima facie also that you are there?
Prabhudananda Rotif is the owner of the dark number, Satya number.
Where is it?
That is para 2.
Peratu does not say that you are the owner.
Rotif that I have enclosed along with the petition that is annexed F.
Yes.
Page 25, your Lordship will find petitioner Prabhudananda Datta. How he is owner Rotif, that was mentioned in page 27, para 5. Some of the other
Anyway,
but
illegal last line too. Yeah. It's a state requisition. It is further revealed from the records that the Divisional Forest Officer Karimganj, who is the respondent number 8, had issued a communication dated 4/10/2004, informing the respondent number 5, that is the Principal Chief Conservator of Forest Assam, that the original estimated value of the land was rupees 4,53,606.55, and the supplementary estimated value as per the Deputy Commissioner Karimganj has been paid by the department. And the balance, therefore, the balance amount of rupees 4,58,002.28 out of the revised estimate of rupees 10,32,418.83 is required to be paid. The record reveals that there were interdepartmental communications between the district commissioner, between the deputy commissioner Karimganj and the divisional forest officer as regards the acquisition of the said land. However, the petitioner, along with others whose lands were taken over by the district administration and handed over to the forest department, filed an application before the district commissioner Karimganj on 16/3/2007, requesting to enhance the rate of assessment and to pay the entire amount to them without any further delay. The record reveals that the said amount, you did not get any money.
that
You have not mentioned anything.
that 5 lakh was
No, they did not disburse.
No.
It is under such circumstances the petitioners had approached this court. Now, the respondents, however, did not take any steps for the purpose of payment of money to the petitioner, disbursing the amount of compensation to the petitioner. And under such circumstances, the instant writ petition was filed, seeking a direction to the respondent authorities to make payments to the petitioner by reassessing the valuation of the land as fixed under the zonal valuation of the land acquired for construction of the office building of the Forest Department within a stipulated period of time. The record revealed that the instant writ petition was filed on 26/5/2015. And this court, by an order dated 1/6/2015, issued notice from the further from the records. An interesting aspect comes into light, more particularly from the affidavit filed by the respondent number 4. It was mentioned that it was mentioned in the affidavit filed by the respondent number 4 that in connection with LA case number 8/84-85, an area of land measuring 15 bighas, 17 chotok, 11 kotha, 11 chotok, covered by various dark numbers and Khatir numbers, were acquired for establishment of the Forest Department building. It was mentioned that the originally an amount of rupees 4,53,606.55 was assessed as the land compensation for the acquisition of the aforesaid land, which was subsequently revised and reassessed as supplementary estimate of the land compensation for rupees 1,20,809.61. That is totaling the total amount being rupees 5,74,416.16. The said amount of rupees 5,74,416.55 was deposited in the Karimganj Treasury by Challan dated 29/4/1982 and by Challan number 1364 dated 29/4/1982 semicolon, Challan number 77 dated 1/4/86 and Challan number 6810 dated 18/3/1991 by the requiring authority, that is the Divisional Forest Officer Karimganj. However, the valuation of the land was again reassessed by the district administration, and the amount became rupees 10,32,818.83. However, the said land acquisition proceedings stood lapsed in view of not making the declaration in terms with Section 6 of the Land Acquisition Act 1891. 1891? 98. 1894. The Forest Department thereupon was again informed to deposit the additional amount of rupees 4,58,002.28 by communications dated 14/9/1992, for which 92. But the Forest Department did not deposit the said balance amount. It has been further mentioned that as per the government instruction conveyed by letter number RLA.45/2004/2 dated 6/5/2004 by the Deputy Secretary Revenue LR Department, the said LA case was again prepared afresh and compensation of the said amount was estimated to the tune of rupees 56,18,392. Under such circumstances, the divisional forest officer Karimganj was requested to deposit the balance amount of rupees 50,43,975.45, which the forest officer, divisional forest officer Karimganj, did not do so. It was also mentioned that fresh LA papers were prepared as per the government direction dated 6/5/2004 and were sent to the requiring department for onward submission to the government in the revenue department of the Assam for approval of the notification and declaration, etc. However, nothing was done. Full stop. It was specifically mentioned that the final estimate as was made was rupees 56,18,392 for the acquisition of the land. A perusal of the said affidavit filed by the district commissioner Karimganj makes it apparently clear that as on the date of filing of the said affidavit, the respondent authorities were holding into the land of the petitioner without any authority of law. The record further reveals authority of law, inasmuch as the acquisition proceedings which were initiated, inasmuch as in the acquisition proceedings which were initially initiated stood lapsed, and press acquisition proceedings was never initiated. Neither. Also, it is also relevant that no payment also was made to the petitioners. In the backdrop of the above, this court also further finds it relevant to take note of the affidavit in opposition filed by the respondent number 8. In the said affidavit in opposition, it was mentioned that there was no statement in the writ petition as to how the petitioners were entitled to any compensation in respect to the land in question. It is specifically mentioned that the order dated 5/12 to 1981 clearly showed that neither the name of the petitioners nor the names of their predecessors were shown as the owner of the land so acquired in connection with RC number 7 of 1981-82. And there is no mention in the writ petition as to how the petitioners have become entitled to the compensation. It was also mentioned that out of the Khatiyan numbers mentioned in paragraph number 2 of the writ petition, Khatiyan number 638 and 630 are not included in the said order. It was further mentioned that the forest department had duly paid an amount, deposited an amount of rupees 5,74,416.55 in 3 installments. It was also mentioned that the compensation was duly paid, deposited before the district commissioner. But it was on account of the negligence on behalf of the revenue department that the notifications were not published. It was further mentioned that there was no question of enhancement of the compensation. This court had duly heard the learned counsel appearing on behalf of the petitioner as well as the counsel appearing on behalf of the district administration. However, none has appeared on behalf of the forest department as well as for the revenue authorities. Yes, what is your submission? How can you keep their land?
It's not shown in the court circular, that's why we keep it.
Your name was shown SC Finance. You are finance.
Finance, that's why revenue
Then-
matter we should keep.
Finance is there. Now, what is your case? Can you withhold their land without any authority? You can't. So I direct them to inquire as to whether the petitioners have any right over the land, and if there is so, to vacate that land within 30 days from the date. None has appeared on behalf of. However, none has appeared on behalf of the forest department or forest. From the materials on record and the contentions so made by the learned counsels for the party, 2 issues arises for consideration. First, as to whether the respondent authority would have any right to retain possession of the land without following the due process. Number 2, what reliefs the petitioner are entitled to in the facts of the instant case. From the pleadings, it is apparently clear that though the respondent authorities have initiated certain proceedings by acquiring of the land in question, the said lands were not acquired. Under such circumstances, can it be said as to whether the petition respondents have an authority to be in possession of the land? The respondents are a state within the meaning of Article 12 of the Constitution. And as such, they cannot be permitted to take over the possession of the land of the private individuals, save by authority of law. Admittedly, as there has been no acquisition proceeding or the purchase of the land in question, the question of the petition of the respondent forest department to retain the land without retain the other than by authority of law would amount to an infraction of Article 300A of the Constitution. It is also well settled that the right over the land, as held by the Supreme Court, is akin to a human right, and the same cannot be taken away save by authority of law. Under such circumstances, this court is of the opinion that without any acquisition proceedings as contemplated in the law or by way of an outright purchase of the land, the respondent forest department has no authority to remain in possession or construct any buildings over the land in question. This leaves this court to the second question, point for determination as to what reliefs the petitioners herein would be entitled to. This court have duly perused the writ petition and could not peruse the and had made a pointed query upon the learned counsel appearing on behalf of the petitioner as to on what basis the petitioners herein claim their right over the land in question, claim rights over a part of the land in question. Nothing could be shown except an application so filed before the district commissioner seeking enhancement. The same is, in the opinion of this court, not sufficient for forming an opinion that a petitioner have any right over the land in question.
But it- and how it got one
No, you should have brought some document to the effect.
but in the representation they have how
No. Representation, why should I look into this representation?
it
Why haven't you made the petition on an affidavit?
but if they have purchased from the vendor, then vendor
Then if you have purchased it, then you have a right of the sale deed. Why haven't you brought on record?
that lordship everything the vendor
No.
in the
And this representation is on affidavit.
lordship find page 29 they have written the name of the vendor of the petitioner number
Absolutely no.
is listed in
You-
the state notice by
These
serial
things
number.
are required to be submitted before the division bench. Next. Legally. Forming an opinion that the petitioner forming an opinion for issuance of a writ against the responding authority more so when the relief which have been sought for is only pertaining to reassessment. enhancement relief has been sought is for enhancement of the payment relief have been sought for making payment to the petitioner by reassessing the valuation of the land as per the zonal valuation of the land acquired. It is also the opinion of this court that when the land had not been acquired, as mandated under law, the question of issuance of a writ for reassessing the valuation of the land as fixed under the zonal valuation of the land does not arise. However, this court grants the liberty to the petitioners to approach the district administration, more particularly the district commissioner, Karimganj, on the basis of the observations so made herein above, that the forest department does not have any right to remain in possession of the land in question. And upon satisfying the district administration that the petitioner is the owner, has a right over the lands in question, the district administration shall take appropriate steps for vacating, for evicting the forest department from the area of the land which the petitioners are in possession. The petitioners have rights. The said exercise be carried out within a period of 6 months from the date a certified copy of this order is served, along with the details furnished as regards the right over the land which is in possession of the forest department. The above exercise, though directed to be complete, shall not, however, preclude the district administration would not preclude the revenue department, the district administration, as well as the forest department to take a decision as to whether they would like to acquire the land within this period and take effective steps in that regard. Should have filed a better petition and give you, otherwise this is the fifth case for getting you the possession within 2 months.
Only because of my lapse on the part of the forest department to deposit the compensation. So revenue is the
Whatever may be, that has already acquired. You can't retain the possession.
absolutely no.
But one thing good, with this direction now, you may not get initially so soon, but they will now take step for acquisition. And as of now, you'll get a huge amount.
Yes. At that point of time, my lord, only it was a question of 56 lakhs. They did not deposit. Now this is the fallout.
And actually, the hearing officials should be taken.
Absolutely, my lord. It's public money, from the exchequer it's going.
Absolutely. No, the amount was how much? Not 556. The amount was 5 lakhs.
5 lakhs 74.
No, it was 5 lakhs. And
Yes.
then it became 10 because there was a delay. And then it became 56.
5 lakhs was not. Now,
Five?
had it been paid, my lord, had it been deposited.
No, they deposited this 5 lakh. But there was the deposit was late for which section 6 declaration was not made.
Yes, that is the
Now,
reason.
after that, they again reassessed, made it 10 lakh.
10
Now
lakh.
there has been no deposit. And then that entire thing lapsed.
Yes.
And then again, there was a direction to take de novo, it became 56 lakhs.
66 lakhs. Yes. Now it will purpose whole thing.
I'm applying for.
Yeah, উপর খালি একটু ধরে তারপর revenue department. Yes. What is this item? Right. You are there.
There is filling surplus land matter. Originally it is Tibetan land. There are
Originally?
filling surplus. So
Then who are you?
our forefathers were is in the possession of the land matter.
Hmm.
And your lordship, just directly I went to annexer 4 matter. What is the
Nectar 4.
stand of the government?
Hmm.
My lord, it is an application filed to the authority, my lord, that there should be a road. And on that basis, my lord, detailed report has been prepared. This is by the sub-deputy collector Katigar to the deputy commissioner Kasar. It's of dated, my lord, 21/5/2018. 1980. Subject petition dated so submitted by Allotment.
Yes. Now what is your
Now your lordship would be pleased to see the list. My lord, this photocopy is also there, my lord. So my lord, your lordship would be pleased to see
which one?
22.
Date?
No, my lord, page 22, my lord.
I've read it.
Type document.
Ah.
Meter, Sona meter.
Ah.
So is the name of the proposed allotment. So, my lord, as on date, my lord,
Sona
out of
meter.
the 7,
Ah.
out of the 7 persons,
Ah.
6 were given patta. The allotees were given patta. Only, my lord, petitioner before your lordship left. This is the case. So, my lord, now the government want to say that we are not in possession. So they file an activity of
You are not given patta.
but not given.
What were you given? Nothing. Then
Well,
what happened?
Not your lordship would be pleased. So, my lord, file an affidavit in opposition. So, in the affidavit in opposition, my lord, they taken the plea that the person concerned is not in possession of. That is their. Then your lordship directed them to file another additional affidavit. My lord, that additional affidavit was filed on 1918. It was filed by my lord Deep Moy Thakuria, assistant commissioner. On 6/6/18, your lordship directed them. Filed.
Your father's name?
My lord, my father's name,
Govinda Mitra.
yes. So, my lord, your lordship
No,
has
no, no. What
taken
is your father's name?
the additional affidavit. My father's name. I thought, Sonaton Mitra.
Huh?
Sonaton Mitra.
His name is not there in Annexure B.
My lord, your lordship taken this additional affidavit.
Hmm.
My lord, that in that additional affidavit, my lord, your lordship would be pleased to see serial number 13.
Bindu Bhushan Paul.
My lord, 13. Govindo Mitra. son
That
of
is what, that is 14. That is why I asked you, what is your father's name? How are you connected with Govindo Mitra?
My lord, your lordship. Your lordship would be pleased to take my eviction.
Huh?
Writ petition, my lord.
Huh.
There are that, my lord, Govindo Mitra is my predecessor teacher. There are two men.
Hmm. Your
Petitioner
predecessor is
grandfather late
Lakshman
Mitra.
Mitra.
Grandfather Lakshman Mitra. Now, my lord, Lakshman Mitra is the father of Govindo Mitra.
Huh?
Lakshman Mitra, man.
Is
Your
the
lordship.
father of
Petitioner grandfather late Lakshman Mitra.
Govindo Mitra, son of Lakshman
Lakshman
Mitra.
Mitra. Lakshman
So
Mitra.
that means, no.
Lakshman
So,
Mitra was
no,
my
no. Therefore, your grandfather, if your grandfather is Lakshman Mitra, your
And
father would be Govinda Mitra?
great grandfather is Govinda.
How?
Yes, my lord. If your lordship see,
Govinda Mitra, son of Lakshman Mitra.
yes, my lord.
Then, if your grandfather is Lakshman Mitra, then your whose son will be Govinda Mitra?
So, my lord, here,
So
here
your father would be Govinda Mitra.
from this record, I want to show before your lordship that we are predecessor in interest of this Govinda Mitra and Lakshman.
Huh?
We are linked to it.
How are you linked?
Right.
There might be, you see, yes, Govinda Mitra, son of Lakshman Mitra.
Govinda Mitra, Lakshman Mitra.
No,
So, my lord,
whose son?
we want
Who,
to
no,
say
no. Who is Govinda Mitra?
petitioner's grandfather was Lakshman Mitra.
So,
Right.
which son will be Govinda Mitra?
Hello, Govinda Mitra.
So, your father is Sanatan Mitra.
Yes, ma'am.
Then how will you connect it?
Well, your lordship would be here. Annexure 4.
Yes.
East and close.
What does he say?
Case 28, my lord.
Yes.
Shona Mitra. So, my lord, case 28, serial number 7.
Yes. Son of?
Shona Mitra, son of Lakshman.
So?
Madam.
Una Mitra, son of
Lakshman.
Una.
Shona Mitra.
Una Mitra. It's the son of Lakshman. That means you are saying Govinda and Suna are both brothers.
Maybe, my lord, but your lordship would be pleased to see annexure number 4. My name is Shona Mitra, son of Lakshman.
But as per the allotment, it was for Govinda Mitra. Allotment was to be made to Govinda Mitra.
No, my lord, not Govinda Mitra, Shona Mitra.
No, no. As per the allotment which have been included. Serial number 14.
No, my lord, page 28, my lord. That is also government document. My lord.
That is a document, but this is also a document.
So, my lord,
Annexure B.
your lordship, I am linked with Lakshman Mitra.
So, how does it matter?
Shona Mitra is my father. My lord.
So, can Lakshman Mitra have no one son staying at this particular tea garden, the other staying at United States of America.
My
So
my
does
humble
that, because of the fact that the son who is staying out there in air, his name is Bhupinder Mitra, whether the son of Sona Mitra who stays in United States will have a right for that?
no, my lord, my humble
I would have understood. If it was given to Lakshman Mitra, you may have a right.
yes,
But
it is
It is
if
not
it
to
is given
Lakshman
to
Mitra.
Sona Mitra, my lord. If it
So
is
it is
given to
Sona
Sona
Mitra,
Mitra,
nothing.
Sona
Don't have
Mitra,
the list of allotment.
my lord. If it is to Sona Mitra, my lord, page 28. If it
Have
is
you
to
made the
Sona
Govinda
Mitra,
Mitra a party?
my right will come, my lord.
All right, won't come.
My lord, I am the son of
You are not son, you are the daughter. You are Srimati.
Bina Mitra, son, daughter of Sona Mitra, my lord. So, my lord, page 28, Sona Mitra, and it is the document, my lord. It is said
Now, whatever may be.
Name
Let us
of-
not go into this Sunamita. No. Now, why that Sunamita was not given, or your Sunamita was not given? Why?
my lord, that is our case, my lord. It is not given.
Why?
6 has been given out of 7.
Why?
We have not given.
Why it was?
That reason, my lord, because, my lord, we are poor
The
person.
reason is very clear. That particular land is to be used for the purpose of making public roads.
No, my lord, your lord, that is, your lordship is to bear with me. Let me read this, my lord. In
You will come
following
under.
herewith
No.
above
First of all,
mentioned-
no,
above mentioned
Mr.
petition in original 3 sheets. I
No,
have honored to state that the applications are resident of village Bishamberpur, so my lord, and they have prayed for public road from village so via so over ceiling surplus land. So far inquiry made into the matter, the prayer of applicants is genuine, and the road as prayed for is most essential for general people as well as school going students of village so to reach them up to the main road for communication towards the places. Road is already in existence up to Swanso. Now, as shown in the trace map enclosed, total area 1 biga 1 katha 13 satak of land from tag number 224, 220, 254 and 256 of Muza Velagora is required for construction of road. Land of tag number 224, 54, 256 Muza Swanso is ceiling surplus and acquired from Salalpur T, remaining under possession of following allottees, whose names are also approved for allotment by DC Kasar in 1977. But allotment certificate have not been prepared and distributed, and physical possession has also not been handed over to the proposed allottees mentioned below. Under the facts stated above, and in greater interest of public, an area of 1 biga 1 katha 13 satak of land from allotment paper of following allottees may perhaps be excluded for construction of public road subject to your kind approval, and the said area may be kept reserved for road to be constructed by GP and allotment modified as detailed below. Name of proposed allottees concerning ceiling surplus land. Serial number 1 and then 7, my lord, Sunam. So, my lord, after land given to the road, my lord, what land remain, my lord? 1 biga, 15 lesa, and 3 sata. Is in my possession.
No.
Remaining land.
The fact which appears out there, yes, these 7 persons were there, were supposed to be allotted. Allotment certificate has not been. But these people were in possession of 1 biga, 3 kathas, 11 chatas or something to that effect.
Ah.
And these particular land, instead of being given the allotment, this land be reserved for road. This is the order.
No, my lord, total, no, my lord, total land is 3 biga, my lord. Your lordship, after taking land for
This is what is
road,
the
my lord.
scope and ambit of particular
My lord,
order.
remaining land is with us. My lord. They want land, my lord, 1 bigha, 1 katha, 13 satak. Oh, my lord, but allotment certificate have not been prepared and distributed physical possession has also not been handed over to the proposed allotee. Under facts and stated above, in greater interest of an area of 1 bigha, 1 katha, 13 satak.
And interestingly,
Now your lordship would be pleased to see what was the land with me, my lord, 2 bigha. Total already.
how can
proposed
you
for
have
allotment
2
in the
bighas
name
of land?
allotee. 2 bigha.
How can you have 2 bighas of land?
Yes, my lord, 2 bigha, my lord, because your lordship would be pleased to see my writ petition, my lord. Actually, 9 bigha was allotted.
How many kathas make 1 bigha?
5 katha.
No, this is a chatak business.
My lord. Anyhow, my lord, your lordship would be pleased to
20
see.
chataks. 20 chataks makes 1 bigha.
Now your
20
lordship,
kathas.
now your lordship
Isn't it?
would be pleased to
So
see.
now I kindly come to page 65, Annexure B. Your Govinda Mitra was only given 11 kathas, which is half bigha.
Now your lordship would be pleased to see para 2 of my writ petition.
Your two have
My
to
lord.
be.
Yes.
Now what is to be done is what? You are
Comprising 9
entitled
bigha.
to.
Your lordship in the middle, comprising land, utilizing the land.
Anyways, Mr.
My lord.
I've looked into your thing. Yes, let's hear the government.
Affidavit is very specific, my lord. Lordship may come to
I've looked into it.
Right.
Now, what is it?
paragraph 8.
No, whatever may be,
Right.
the land was acquired, there was ceiling surplus.
Ceiling surplus. So it is
Now, if it is ceiling surplus land, this is a T land.
It-
If it is a T land, then you are to give it to those T people as per the Assam fixation of link. Now, yes, you can very well reserve for your roads, whatever may be, the remaining which is ceiling surplus, otherwise which is not required, is to be given. Now, the question is whether the petitioner's thing was duly considered. Yes, you have taken out that, but have you also considered
might
them for any other land?
he might have told or something to other people.
That is what I could see from your affidavit,
Yes.
that they have told and left.
That word,
And
my
they-
lord, told is not here.
Huh?
Nowhere.
No, it is
has been
there.
said that
It is very categorically there in the affidavit.
told is not.
Yes, kindly see
Paragraph 8.
paragraph number 8. That so and so that a portion of the land pertaining to area is of Balaswe Kundri Road and the correction is also to area. It also appears from spot inquiry that petitioner's father left the place by handing over possession of the land to others. An allotment has been made in favor of persons who were found in occupation.
Left, it is said left. Now your lordship would be pleased to see affidavit in reply, my lord. We have annexed a document. Your lordship, that is an affidavit in reply.
Hmm.
Filed on first day of June 2016.
Hmm.
To that affidavit in additional affidavit.
Hmm.
Now your lordship,
What is this value of this document?
my lord, it is given by Panchayat president as a
So how does he have any relevance?
locally know it, and it is said that the allotment has been made to some persons who have gone for.
Kindly see here. Kindly come to number 13, serial number 13 of that document. There you see the difference, why this is happening. Govinda Midra, son of Lakshman Midra of so and so. He is the brother of Sanatan Midra.
Yes.
Both are factory workers. His brother, Govinda Midra, has been allotted 11 kathas. That is what is there in the allotment certificate, which have been enclosed to the reply. Whereas Sanatan Midra have not been allotted any land. This makes it clear everything. So you don't have any case coming up. Get to meet. that order, which is there in Annexure 4,
Yep.
is an order in terms with Section 7. So if that be so, can it be said to be an excess land? And if it is not an excess land, where does the question of disposal of the excess land come?
Your lordship needs to see that it is ceiling surplus land, Annexure 4.
Understood. Ceiling surplus land would not. First of all, it is only the excess land which can be disposed. When that land has been specifically earmarked for the road, would it come within the ambit of a excess land? No.
Your lordship would be this. I travel your lordship again to Annexure 4.
Yes, I've read the Annexure 4. Yes.
So, whole reading
Hmm.
is seen. Just your lordship would be this too, subject to correction by your lordship. That here, I am referring to page 27. Here, list of 7% has been given. And lastly, my lord, it is a format is made like this. Name of proposed allotee, first column. Total area already proposed for allotment. Area of land required to be excluded from allotment paper or road. Now your lordship, tag number, name of Moses Noenso, remaining land to be allotted in the name of allotment. So my lord, your lordship, every allotee has got some 2 bigger, 3 bigger, like this original land. Now my lord, your lordship will come to Sonamita, that is at page 28. Sonamita, son of Lokhon, 2 bigger. So for road, my lord, 5 kata, 13 kata, like this. So my lord, remaining land, my lord, your lordship, in the right hand column, 1 bigger, 14 kata, kata. So that land is for my firm. So this is the position. After taking the land for road, my this land left.
So you have proposed two kathas,
But,
and of these 2 bighas,
out of 2 bigger, my lord, one bigger,
1 katha 13 lectures.
13 kata.
Area of land to be excluded is 5 kathas 13 lectures.
30 kata, 13 lesser, then above.
And
my
the
lord,
remaining
3
is 1
14
katha
lesser,
14
3 kata.
lectures. 3
Total
katha.
land they required, my lord, that has been mentioned in the report, my lord, that 1 bigger something. That land for road, my lord, 1 bigger, 1 kata, 13 kata.
No, 1 bigha, no. This is the total area of land to be
Total
excluded.
area of 1 bigger, 1 kata, 13
Yes.
kata of
Who
land.
is paying for the revenue?
So, my lord, page 25.
Mm.
The
Page
total
28.
area of 1 bigger, 1 kata, 13 kata of land from Taknapur to
No, Mr. Porpujari, you see that petition.
page 25.
No, not page 25. Page 27.
27.
This is the final statement, I suppose. See, name of the proposed allotee. It is being given as Sunamita, number 7, at page 28. Okay?
Sunamita, yes.
Then total area of land which was proposed.
Right.
The total area of land which was proposed was 2 bighas. If you see at serial number 7.
Yes, yes.
Okay. Area of land to be excluded from allotment for the purpose of Sunamita is 0 bigha, 5 katha, 13 shataks.
Yes.
And the remaining which can be allotted is one biga 14 katha 3 chatak.
13 setup.
No,
Yes,
3 chatak.
yes.
Because the total which is to be excluded is 1 biga 1 katha 13 chataks.
Yes.
For all the 7.
Yes.
From the proposed, which was proposed, this is to remove and this remains.
Yes.
So here the case of the petitioner is that the petitioner should have been granted this settlement.
1 biga 14 kotha 13 setup.
That is it. That is the case.
Now, this is a proposal.
No, this is not a proposal. Yes, it was a proposal at that point of time. But this is what has been found out by the collector, because this is the signature under the signature of the deputy collector
Yes.
in 21/5/2080.
So, on paper, this 1 giga 14 less than 13 setup has been earmarked on paper. Now, let us see, my lord, Regulation 41 of the Assam Land and Neighborhood Regulation. If this is allotted, the consequence will be correction of record of right.
Hmm.
He will step into the shoes of a pattadar. He will become a pattadar. Now, what 41 says? Entries in the record made under section 40 shall be founded on the basis of actual possession. So actual possession is a condition precedent. And all disputes regarding such entries, whether taken up by the settlement officer of his own motion or on the application of party concerned, shall be investigated and decided by him on that basis. And all persons not in possession but claiming the right to be so shall be referred by him to the proper court. They are laying a claim on the basis of, my lord, this page 27. This is their claim on paper. But to execute that, my lord, that allotment or proposal, as I would term it, the condition precedent is that they will have to be in actual possession. Now, the affidavit says that they were not found in possession and no test could be made up. This is what the affidavit says. So this is the difficulty. One has to be in actual possession because I am claiming a right. 41 is clear. Entries in the record and the asset.
No, this is a stealing surplus land.
Maybe sitting surplus debt, but this is if it is required to be settled, then, my lord, there has to be possession.
Now, if a person is only in possession, can be settled, not others. In terms with the Assam fixation, land fixation of stealing surplus. No.
Fixation, therefore, my lord, section before that, my lord, let me read the affidavit, my lord. Lordship will kindly take up the affidavit, my lord, filed by one Timothy Dorothy Sustian. Affidavit, my lord, on behalf of respondent 3 and 4. Here, my lord, at paragraph number 7, may I read it, my lord?
Yes.
That with regard to statements when the economic to say the land measuring 9 bighas, 3 kothas, 1 katak only under second RS dark number 256 of Moja, Belfarpal, Grand Pargana, Dalalpur was made filling fast, white land filling case number so and so, dated 7/6/1976, and allotment was made in favor of different landless persons who were in occupation of the land. Occupation of the petitioner or his father over the land filling fast land is not found on the spot at present. There is no trace in the record regarding allotment of name in the name of the petitioner or his father. Then paragraph 8 says, my lord, it also appears from spot inquiry that the petitioner's father left the place by handing over possession of land to others, and allotment has been made in favor of the persons who were found in occupation.
Then paragraph 9 also, my lord, it is repeated, name of petitioner or her father or grandfather is not found in the list of allottees and she is not in possession of LC first land at present. Then paragraph 11, my lord, it appears from report that allotment of land measuring 10 kotha pertaining to land ceiling first so of the state Moza and Pargana was made in favor of Lokhan Midha, son of Govinda Midha, and no trace of occupation of other legal heirs of late Govinda Midha is found. As the petitioner is neither an occupant nor an allottee, so conversion, conservation of the allotted land, conversion of the allotted land to annual patta or periodic patta does not arise. Now, if we come to, my lord, the provisions of, my lord, section 16 of the 56 Act.
Yes.
Section 16, the manner of disposal of excess land. If there is any cultivating tenant in occupation of the land acquired from an owner, then he shall be given settlement of such land within a prescribed period on the following conditions, namely, number A, that the land so settled together with any other land held by him or member, either as tenant or owner shall not exceed the aggregate limit fixed. Then B, we shall pay, my lord, these are not relevant for our purpose, but here section 16, my lord, provides that if a plot of land, my lord, that has been acquired as ceiling surplus land of a particular person, and if it is found that under that person there is a cultivating tenant, then, my lord, he will have the first preference. And in fact, the land has to be settled in that manner.
No, if it can't be done under 16, then you have to resort to 17.
17. So therefore, my lord,
17 does not say that you have to be in occupation.
so 17 does not say any occupation, but we have to read it along with, my lord, regulation 41.
No,
Because
regulation 41 is there, but if, how do you take care of 17?
No, because
The 17 categorically says that in making settlement under subsection 1 of this section, preference shall be given as far as practicable to the following categories of person in the order of merit. Landless dweller who has been rendered homeless,
Yes.
landless cultivator,
Yes.
agricultural land for the purpose of landless shall mean it does not hold any land, whether as owner or tenant, both exceeding 3 bighas, of
And
whose only means of air is
livelihood
cultivation.
is cultivation.
Okay.
Yes.
Now, if that is so,
Yes.
out there, so this is the 17 on which it can be given.
Yes.
So we are to go, although power has been given to do so in terms with the settlement rules, but there is a special exception by which 17.2 and 17.3
Yes.
duly plays a part
Yes, but
in
there is,
respect of fixation of.
yes, Rossi is absolutely correct. But may I add further, but there is a qualification in section 17 also. If a person to whom allotment or settlement is supposed to be offered, he has to be a minor cultivator.
Yes, there's no quarrel with
Yes.
that.
Now, whether
No,
in
therefore I'm saying,
in the writ petition,
although section 17.1 says that it cannot be disposed of under section 16,
yes,
then you are to go to section 17.
absolutely,
Then in section 17, it is further qualified by 2 and 3,
absolutely,
which says that he has to be a cultivator.
right.
Now the question is, what do you say about this order by which there was a proposal for settlement, which has been made? That this is a certified copy of an order of the Deputy Commissioner, wherein it says that there was a proposal being made for all these 7 persons. However, in view of the land, if some land is required for to be taken for the road, the remaining portion can be very well settled, but these portions should be taken, of which the remaining 6, as per the petitioner, have already got the land, however the petitioner has not been given.
Yes.
That is the case of the petition.
That is the case. And the pleaded case of the respondents in the affidavit is that those 6 persons were found in actual possession. Those 6 persons were found in actual possession. So therefore, they were given, my lord, the settlement. Now he, and for that matter, neither her or for that matter, her predecessor in interest was not found in my lord possession, actual possession. And that is why, my lord, the settlement could not have been made. This is the prerequisite.
But how, if we look into this order of that particular order of 1980, it categorically shows that these people finally come to this page 24.
My lord.
So far, in between, so far, an inquiry made in the matter, the prayer of the applicants is genuine, and the roads as prayed for is most essentially as well as so and so. Then here it says the road is already in existence up to so and so. Now, as shown in the trace map enclosed as total area of so and so, from dark number so and so is required for construction of the road of dark number 224, 2254, and 256
Yes,
of Moses so and so is a ceiling surplus land acquired from so and so remaining under the possession of the following. See, remaining under the possession of the following proposed allottees whose names are also approved for allotment by so and so, but allotment certificate have not been prepared and distributed, and physical possession has not been handed over to the proposed allottees mentioned below. Meaning thereby, so those other persons who have been given, they were also not given the physical possession.
yes.
If that be so, then how do you distinguish between 1 to 6 with 7?
No, my lord, down under, my lord, under the fact stated above, and in greater interest of public, an area of 1 bigha, 1 kotha, 13 stocks of land from the allotment papers of the following allottees may perhaps be excluded for construction of so and so public road, subject to your
Subject to the approval of your kind approval, and the said area may be kept reserved for so and
so road,
and
to
the
be
allotment
constructed.
list modified as detailed.
Okay.
Now, this is written by whom?
It is
By the sub-deputy collector to whom? To the deputy commissioner.
sub-deputy collector. Yes, it's a, my lord, part of an order sheet, my lord. Office.
No, it's not an order sheet. Kindly come to page 23.
Yes, page
This is a
23.
communication. It's a certified copy of a communication.
Names of the parties. Office, the deputy commissioner. Yes, this is the communication. Yes.
So this would not come within 7.
So here it is said, my lord, if we go by this document, then what transpires is, my lord, that none of the persons to whom proposal was thought to be made, allotment was thought to be made, were never in occupation. They were not in occupation, but nonetheless, my lord, proposal was made to, my lord, to allot land. But from the affidavit, my lord, it says otherwise.
Now, paragraph 8 of the affidavit in reply says that they are in possession of the land in question, being the legal heirs of the lawful allottees of the government by paying revenue to the authority against their land. Yeah. Now, you are saying that you are in possession. Where is the revenue receipt for these lands?
But revenue receipt.
Huh?
Revenue receipt for the trustee. Trustee would turn to page 35.
Page?
Page 35 of my writ petition.
Yeah.
Bina Middaman.
This is in respect to which dark?
Lord, this dark, my lord. Yeah, what happened? Some levy was made, my lord, in favor of somebody. So thereafter, my lord, when I am in the position, my lord, so that receipt has been.
No,
I
this
paid
shows that it has been paid for many years.
14, 16, 14, 17, 18, 14, 19,
Hmm?
21.
No, this is in respect to which dark?
No, Lord, this is your lordship in the left-hand column, you will see 27 number, Meti month. It has been turned into Meti. Some portion made already make Meti.
So it is in the
That is
name
our
of
case, my lord. That Patta has been issued
Bolestor,
to
Bolestor what?
Baleshwar
Name in the area Bolestor Grant.
Baleshwar Grant.
No, Moza.
It is the Moza. Then lordship will see down below Marfote. Marfote Bina Nidha.
Marfote means received from.
Yes.
But in respect to what dark or area, Hotian or something?
No,
Actually, my
that
lord,
lordship will find in the left hand column, my lord.
Hmm.
27 number. Miati.
Meti.
27 number.
So why did you pay in respect of Miyati land?
Meti, my lord. Meti, regarding Meti, my lord, my explanation is like out of 7, my lord, 6% already given Patta. That is our case.
So your land today has
have
become
not been
Miyadi?
given. So my land included in this area.
No,
So I have-
understood. But has that land been, if it is made Miyadi, obviously there is a grant of a patta in favor of somebody.
But grant is given. My case is, my lord, Meti has been issued in respect of
Miyadi cannot be in respect of a land which is belongs to somebody else. Means there is somebody else who have been granted the patta.
But that is our case. Out of 7%, 6 are granted.
The entire land.
Yes.
The entire land has been
Not
granted.
the entire land. Our portion is not.
Then if your portion is not there, then it can't form a part of the Miyadi land.
Not Meti land.
Then why are you paying in respect to the Miyadi land?
Regarding this, my lord, that I am in possession of a particular that area. So, my lord, regarding this, my lord, Meti revenue has
No, this revenue has no relevance to with the
Yes,
land.
yes. Anybody can pay. So therefore,
Anybody can
that-
pay.
that-
anybody can pay.
Why did you
that
pay
your-
for somebody else?
that your lordship can hold, that it is a Meti land.
If it is a Miyati land, it has no revenue. And then let us see any other document to show.
Only thing your lordship will consider, your lordship directed them that you have allotted, you have given patta to somebody. So you produce the record. In reply to that, my lord, they say that we have lost the record. Your lordship was pleased to direct them by an order.
Are you in possession of the land still?
Yes, my lord. I am in possession. That is my case. My lord,
And
your
are you a cultivator?
originally, my lord,
Originally, no. Now,
factory worker.
no, no. If
Now cultivation.
no,
Cultivation.
now the question is like this. This court has to direct the respondent authorities to exercise the powers under 17.
Yeah.
You are not a recorded tenant,
No,
so 16 won't come.
No.
So you have to go by 17. Now, if a 17, can it be applied to you if you are not a cultivator?
I'm a cultivator. I use the land. That is my contention. Your
Ah.
lordship would be pleased to be in my repeating.
Are you cultivating?
Yes.
Yes, where?
There are two possibilities.
Two.
Yeah.
Yes, where?
No, I do not find any specific environment that can show it.
That's correct. But I will point out.
There has to be a specific environment.
Your lordship would be pleased to see in the middle, my lord.
Huh?
Father of the present petitioner
Are you utilizing the land?
had been possessing and utilizing the land during his lifetime.
So?
The above plot of land is comprising.
So?
So utilizing the land means, my lord, that word, my lord, is the petitioner, my lord.
It
Even
has
this
to be
is
read
to
as
the
if you are
advocate, my
cultivating.
lord. He written that utilizing the land. So, my lord, utilizing means what? Not that I am residential there, I am using the land. But may I refer to page 30, my page 30, that the petitioner is extremely poor man and dependent on his land for his livelihood.
8,
Page 30,
30.
30 meter of my writ petition, paragraph, that the petitioner is extremely poor man and dependent on his land for his livelihood, taking advantage of poverty and helplessness.
That the petitioner, where?
Page 30, my lord.
Where is it?
My lord,
Page
paragraph 4.
paragraph 4.
Paragraph 4, my lord.
That curve from the above the one.
No, my lord, writ petition, page 30.
Page 30, it was an application, representation, my lord, made before the deputy commissioner.
Huh?
So the
Page 30 is a representation.
Yes, the repeated, your lordship pointed out to me
Ah.
how the land is used. That is
Yes.
the position, my lord.
Where?
That petitioner is extremely poor man.
Where is it?
At page
Para
30,
Page
30. Okay.
Page 30.
page 30 of the writ petition,
Ah.
that is annexure 5. My
So,
lord,
my lord,
this is a
petitioner is extremely poor man and dependent on this land for his livelihood. So, in para 2, it is said that it is utilized. Now it is, my lord, extremely poor man dependent on the land for his livelihood. So, my lord, that land is used for cultivation, livelihood.
But if you are not a cultivator, how do I give you?
My lord, no, my lord,
There's not a single
Ye-
statement.
my lord. Directly that is not that, but your lordship would
What
be free to
indirectly
look
should
and
I take?
consider that livelihood means.
Livelihood is for
My lord,
what?
my humble submission.
You may
before
be
the lord-
having a shop.
My lord,
First of all, you have a possession or not, that is another question.
my lord, I utilizing this that and that
Chalo.
is the source of livelihood. And another thing,
Enough.
your lordship,
Heard Mr. M.H. the learned counsel appearing on behalf of Mr. Harbor Pujari appears on behalf of the Revenue Department, the government of Assam, and Mr. B.J. Talukar, the learned senior counsel appears on behalf of the government of two state courts. The petitioner herein is being agreed by the inaction on the part of the respondent authorities to allot the land and grant settlement by issuance of the permanent patra, have filed the instant writ petition. The facts as appear from the pleading is that the petitioner's grandfather, one late Lakshman Midha, was working as a laborer at the was working as a workman at the Jalalpur Tea Estate. It has been mentioned that the garden authority had granted settlement of the plot of land to the grandfather of the petitioner. And the grandfather of the petitioner possessed and utilized the said land during his lifetime. It has also been mentioned that after the death of the grandfather, the father of the petitioner was possessing and utilizing the land. The said land comprised of 9 bighas, 1 katha, 3 chatak, located in Moda, Golestor Branch, Porgana, Jalalpur, bearing dark number 256 of the second RS. In terms of the provisions of the Assam Fixation of Land Ceiling, of Ceiling on Land Holdings Act 1956, for short, the Act of 1956, various plots of land belonging to the Jalalpur Tea Estate was acquired as ceiling surplus land. The grandfather of the petitioner, the father of the petitioner, who was in possession of the land, applied for allotment It was mentioned that the father of the petitioner came to learn that there was a proposal to allot some land to the father of the petitioner along with others. It is also seen from the pleading of the petitioner that specific emphasis have been made to a communication dated 21/5/1980 issued by the Sub-Deputy Collector Katigora to the Deputy Commissioner Kachar Silchak. The said communication was issued in connection with a petition filed by one Sri Alok Ahmed Loskor and 117 others paying public road from Bisambarpur to Kusarikul via Bolestor Grant over sealing surplus land. This court finds it very pertinent to take note of the contents of the said communication, taking into account that the entire case of the petitioner rests on the said document. From a perusal of the Annexure 4, that is the communication dated 21/5/1980, it revealed that various persons had applied for settlement, for allotment of the land pursuant to the acquisition under the Act of 1956. At the request of the local people, it was decided that 1 biga 1 katha 13 chatak of land from dark number 224, 254 and 256 of Moza Bolestor Grant was required for construction of a road. It was also mentioned that amongst various persons, the petitioner's father was also proposed to be allotted 2 bighas of land. However, the physical possession, however, the allotment certificate was not prepared and distributed, and the physical possession was not handed over to the proposed allottees. It further revealed from the chart enclosed to the said chart, which was a part of the said communication, that the father of the petitioner was proposed to be allotted 2 bighas of land, and out of which 5 katha 13 chataks of land was to be reduced. It was to be excluded for the purpose of the road, and allotment can be given in respect of 1 biga 14 katha 3 chataks of land. It is the case of the petitioner that various other persons have been duly, the other persons have been granted the settlement, except the father of the petitioner. And as such, the present petition has been filed. The record reveals that the Assistant Settlement Officer, Katigora Circle, Revenue Circle, had filed an affidavit in opposition on 19th of February 2016, stating inter alia that a land measuring 9 bighas, 3 katha, 1 chatak under second RS, tag number 256 of Moza Bolestor Grant, Borgana Jalalpur, was made sealing surplus, sealing Caste by LC case number 13/1974-75, dated 7/6/1976. An allotment was made in favor of different landless persons who were in occupation of the land. It was specifically mentioned that the occupation of the petitioner or his father over the LC Caste land was not found on spot verification. There was also no trace in the record regarding allotment of land in the name of the petitioner or his father. Further to that, it was stated that from the spot inquiry, it revealed that the petitioner's father left the place by handing over the possession of land to others. An allotment has been made in favor of the persons who were found in occupation. It was also, it was further to that, it was stated that the allotment had been made for an area of land measuring 1 bigha, 14 kathas, 3 chataks in favor of different occupants at present. It was also stated that the allotment of land measuring 10 kathas pertaining to LC Grant Caste Dag number 256 587 of the said Moza and Pargana was made in favor of Lakhon Midha, son of Govinda Midha, and not race of occupation or other legal heirs of late Govinda Midha was found, and no trace of occupation of other legal heirs of late Govinda Midha was found. It was stated that as the petitioner was neither an occupant nor an allottee, so conversion of allotted land to annual conversion of the allotted land to the annual patta or the period patta did not arise. At paragraph number 13 of the said affidavit, it was stated that on spot inquiry, the petitioner was not found in possession of the LC Caste land. However, other people who were found in occupation of the land by way of constructing houses, etc. It was stated that the total area of LC Caste, the LC Caste Dag number 256 of 9 bigha, 1 katha, 3 chata, land measuring 6 bigha, 7 katha have been allotted to different occupants. In addition to that, an area measuring 8 kathas is lying under the occupation of the Garden Authority. Further, the Baleshwar Kusiar Kul road had been constructed over an area of 13 kathas, 5 chatak. So the total area under utilization stands at 7 bighas, 8 katha, 5 katha, and the remaining area of the last LC Astra measuring 2 bighas, 14 is presently lying under the occupation of different people by way of constructing houses, etc. But no trace of occupation of Mirda family was found on the spot. To the same affidavit in opposition, an affidavit in reply was filed by the petitioner. It was mentioned, amongst others, that the ceiling surplus land by the government from Jalalpur tea state in the year 1976, the petitioner's father was in possession. It was stated that as per the government policy, initiative was taken to distribute the said land to the landless persons who were in possession. Accordingly, necessary inquiry was carried out to propose to allot the same to the deserving persons, including the deponent, the petitioner's father, by DC order number 23/75-76/31 dated 7/5/1977, which is amply clear from Annexure 4 of the writ petition. It was mentioned that on the other hand, on one hand, the responding authorities did not grant the allotment in favor of the petitioner, but allotted the land to some other persons who were not at all entitled to. It is further relevant to take note of an additional affidavit filed by the respondent number 3 and 4. In the said additional affidavit, it was stated that the allotment of land under dark number 256 of Moza, Baleshwar, Pargran was made in the year 1983-84. And as such, the old order documents were not found available with the Office of the Assistant Settlement Officer, Katigora Revenue Circle. But on the basis of such earlier order, names of the allottees with dark number and area allotted were found in the authentic second RS Chita book. Three documents were enclosed to the said affidavit, additional affidavit. Amongst the various three documents, Annexure A to the additional affidavit is a document issued by the Assistant Settlement Officer, Katigora Revenue Circle. Providing information in terms with the orders passed by this court. Annexure B is the list of allottees from a perusal of the same. From a perusal of Annexure B, it reveals that there were already 17 allottees pertaining to Caste LC grant number, Caste tag number 256. It was also seen it is also seen from Annexure C that there are 5 persons who were found in occupation of the remaining land of the LC grant Caste land of tag number 256. From a perusal of Annexure B and Annexure C, the names of the petitioner, or their father's name have not been reflected. To the said additional affidavit, an additional affidavit in reply was filed by the petitioner, stating inter alia that the petitioner, that the land in question measuring 1 biga 14 katha 3 chatak is in clear possession of the petitioner, and there is none on occupation of the said land except the petitioners. Further to that, another affidavit in reply was filed by the petitioner, stating inter alia that the list of allottees enclosed with the additional affidavit as Annexure B is not connected with the land in question measuring 1 biga 14 katha 3 chatak covered by dark number 256. And the petitioners are in possession of the said land, and there is no other occupant over the said land. In the backdrop of the pleadings, this court have also heard the learned counsels appearing on behalf of the petitioner as well as the respondent authorities. The question which arises before this court as to whether a writ can be issued in the present facts and circumstances for the purpose of issuance of a patta in favor of the petitioner. Admittedly, land measuring 9 biga 1 katha 3 chataks was acquired in terms with the Act of 1956. The petitioner claims that the father of the petitioner was in occupation of 2 bigas of land and accordingly filed application for settlement. The entire thrust of the petitioner's case is on the basis of the communication dated 21/5/1980, which records that there was a proposal to allot land to the petitioner father. After excluding an area measuring 0 biga 5 katha 13 chataks from the originally proposed 2 bigas of land. The said communication further shows that the allotment can be made in favor of the father of the petitioner to the extent of 1 biga 14 katha 3 chataks. Be that as it may, the fact remains that there was no allotment made in favor of the petitioner or the father of the petitioner. The communication dated 21/5/2018 only evidences that there was a proposal for granting of settlement to the father of the petitioner. The record reveals and more particularly from the affidavit in opposition as well as the additional affidavit filed by the respondent authority, that out of the total land which was acquired under the Act of 1956, 6 bighas, 7 kathas of land have already been allotted to different occupants. And the list of the same could be found in Annexure B to the additional affidavit. An area measuring 8 kathas is still lying with the garden authority, authority from whom the land had been acquired. 13 kathas, 5 chetaks of land have already been used for the road. And an area measuring 2 bighas, 14 chetaks is lying in occupation of different persons. However, a perusal of Annexure C to the additional affidavit shows that an area measuring 1 bigha, 12 katha, 14 chetaks is in occupation of other persons in respect of Dag number 256. This court, however, also finds it very pertinent to take note of that the petitioner have not challenged the allotment so made in favor of other persons. But the fundamental question due arises in the instant proceedings as to how the settlement can be made, allotment or settlement can be made if a land has been acquired under the provisions of the Act of 1956. Chapter 3 of the Act of 1956 stipulates the manner of disposal of the excess lands. In terms with Section 16, the disposal of the excess land first has to be made in favor of those persons who are cultivating tenants. Admittedly, the petitioner's father or the petitioner are not cultivating tenants. Therefore, the question arises as to whether the petitioner herein can be entitled to be granted the settlement in terms with Section 17, which stipulate that if a settlement can allotment or disposal, which stipulates that if the disposal of the excess land cannot be made in terms with Section 16, then the Section 17 would be resorted to. It stipulates, Section 17(1) clearly stipulates that the said settlement then has to be done in terms with Section 12 of the Assam Land and Revenue Regulation 1886. Or in other words, the settlement has to be made in terms with the settlement rules as framed under the rules framed under the provisions of the Assam Land and Revenue Regulation 1886. Interestingly, a perusal of subsection 2 and subsection 3 of Section 7 would show that there is a caveat in the manner in which the settlement has to be made. And subsection 2, subsection 3, section 7 would show that there is a caveat in the manner in which the settlement has to be made. And that there is a stipulation. There's not a caveat, there is a stipulation under which the settlement has to be made. It stipulates that the preference can be given as far as practicable to various categories of persons in the order of narration. That is, landless cultivators who have been rendered homeless due to flood, earthquake, or erosion, semicolon, landless cultivator, or agricultural farming corporation as defined in the Assam Agricultural Farming Corporation Act 1973. Subsection 3 of section 17. This court finds it relevant to observe that subsection 3 of section 17 only states that a preference has to be given. Meaning thereby that if there are persons falling within the categories as mentioned in subsection 3 of section 17, they are to be given a preference against other persons. This court further finds it very pertinent, taking into account the facts involved, to take note of section 11 of the Act of 1956, which stipulates that pursuant to the publication of the publication of the final statement, the collector is required to take possession thereof and for that purpose may use force as may deem necessary. Therefore, it is not understandable as to why 8 kathas of land is still in possession of the estate, as have been stated in the affidavit filed by the settlement officer. Further to that, from the affidavit so filed by the settlement officer, it reveals that 2 kathas, 14 chataks of land, have not been settled and is presently lying under the occupation of different people by constructing houses, etc. Meaning thereby that apart from the 8 kathas of land lying in the occupation of the garden authority, there is an additional 2 bighas, 14 kathas of land under the occupation of other persons who have not been granted the settlement. And admittedly, full stop. In addition to the above, this court also finds it very pertinent to observe that in the Annex C to the additional affidavit, it has also been mentioned that 1 bigha, 12 katha, 14 chataks of land is in occupation of some other persons. Who have not been granted the settlement. And a conjoint reading of the affidavit in opposition as well as the additional affidavit would show that these persons are using the land by constructing houses. In the backdrop of the above analysis, the question therefore arises as to whether the petitioner should be, whether appropriate direction should be passed for granting the settlement in favor of the petitioner on the basis of the communication dated 21/5/1980. As already stated, and at the cost of repetition, there has been no order of allotment made in favor of the petitioner or the predecessor in interest of the petitioner. However, if the petitioner is still in possession, as has been claimed by the petitioner in the pleading, which, however, has been denied by the respondents, and this court is not in a position to adjudicate as regards that, the petitioner is required to be taken into account. The petitioner is also required to be considered for the purpose of allotment, inasmuch as admittedly there are lands which have not yet been settled or allotted. This, however, would be subject to verification to the effect that the petitioners are in occupation and in possession of the lands in question. Considering the above, this court therefore disposes of the instant writ petition, thereby directing the district commissioner, which one? Kachar? Kachar? Either by himself or through his delegate, make an inquiry as to whether the petitioner is in possession of the land in question. And if so, then taking into account that there was a communication and taking into account that there are lands which are yet to be settled, and if it forms within the ambit of the excess land, the petitioner may be considered for granting of settlement, allotment of the land. The said exercise be completed within a period of 6 months from the date a certified copy of the instant order be served upon the district commissioner.
Along with minor certified copy of minor order, the petitioner also make a representation stating his entire claim. He may like to file documents.
The petitioner
That
is
will
further directed. এটা লাইন সেই ওপৰৰ লাইন the said verification would be conducted. And for the purpose of verification, the petitioner is given the liberty to submit the necessary papers on the basis of which the petitioner claims to be in possession of the land and has rights which are accrued upon her over the land on the basis of her possession.
All right.
50 rupees. An amount of 9 crore odd was determined to pay that order was also defined paid for 47 is the finding. Act provides that the action to the
What are you referring to?
order was
Page
page 46.
Yes.
The findings of the
you have the government pension now. You have the government pension now.
no, not yet. It's going to affect has also it has also defined by that
Hmm. Hmm.
these orders of jurisdiction that act not applicable to the asset.
You take
Still one
of
of Act,
which act?
Employees Provident Fund Act
1952.
page
16.
One.
1C.
16 covers alert act not to apply to certain covered by
The act shall not apply
to
any other substance set up
under any central, provincial, or state act. Is under the state act, and whose employees are entitled to the benefit of the contributory fund or old age pension according with any scheme or rule framed under that act governing such pension.
Now you are having
We have-
benefits of contributory protection.
Yes, there is a provision fund rule. We have annexed it to the law.
No, are you to the benefit of the contributory provident fund? Are the employees entitled to that?
Okay. That rule to be fine at least
Page 15. Yes.
people. Now, as the accept have a rule under the act, these rules are framed under section 10 of the act.
No, understood. But are these people entitled to?
Yes.
Are they getting?
Uh, Annexure H, page 49.
Page 40?
Right.
These people are getting it.
Yes.
Yes, Mr. Roy.
My lord, this question was raised and I was asked to file an affidavit. I filed an affidavit. Have a look. My lord, this provision of section 16 1D is not applicable. And there is a Supreme Court decision to this effect. I just raised to court. Yes.
Because his entire case is that
I
try
understand.
to see his
No, my lord.
reply, which has been made out there on the basis of which the order has passed.
No, Lordship, I understand. So, now, my lord, Lordship will kindly have a look at the first, the rule they have cited me at page 16. Then I will come to that, my lord. Okay. Page 16 is the scheme that has come in 1962. Lordship will come to page 17. Three, your Lordship got in the middle, 4-3. Contribution to the management of the fund. The undermentioned categories of staff of the board shall not be eligible to subscribe to the fund.
Where?
My lord, 4-3.
4-3.
Paragraph 4-3. Lordship has got it, my lord.
4-1, 4-3. The undermentioned category of staff of the year shall not be eligible to subscribe. Government
Subscribe to
servants
fund.
and employees of other bodies or institutions on deputation. Obviously, that
Then
that is no
second
problem.
is daily wages
Because
employees.
these government servants are entitled to pension.
Sir.
So that is out.
Second is daily wages employees of the board. Employees whose terms of employment are governed by the special contract.
So these are the two.
Yeah. So this contractor, Lordship will kindly come to take up the act provisions of the act first. Lordship will take up the provision of the act first.
But the thing is, your finding at page 47 does not say anything about these two.
They have not raised this.
No. They are specifically saying that as per this particular scheme, we are entitled to, we are giving all the benefits.
They have raised this here.
No.
No, my lord.
That is, kindly see here, page 46. Establishments from content. Down below.
No, I understand. My lord, they are given the Lordship kindly use the affidavit opposition file. They are covered from 1986. From 1986. This 16 came in much after that. This provision of section 16 came much after that. But that's why Lordship will kindly have a look at my additional affidavit that I have filed. This section 16 has come in 1988 for the first time. Section 16 B and C. This is substituted. I have annexed my note in my affidavit, page 101.
He was there.
16, no, 16 was there. 16
was there. 16C.
B and C.
He was not there. But
B and C was substituted. Earlier B is substituted. Earlier B was different. I have annexed that original one, my lord. Lordship will kindly have a look at the that affidavit there 17/7/2023.
Yes.
First, Lordship section page 96 serial. The original section 16, my lord. Act shall not apply to certain establishments. First is there is no change.
To any other establishment employing 50 or more persons for removal of doctors. So this was B.
B was substituted.
And B and C was brought
B and C was it. B
from
and C came,
1988.
my lord,
From 1988.
88. So they were the covered, they were given their number, and they have contributed also. So therefore, they are covered from prior to 1988. Now after 98, it's true. But not after 1988, the amendment has come. Now, Lordship Supreme Court has held that to be covered under Section 16B or 16C, there are two conditions. Lordship will have a look at one paragraph. Pawan. My lord will kindly come to paragraph 10, paragraph 10.2 first. This is the provisions of the Act, my lord, it's quoted at page 5 and 5. Lordship got it, my lord.
Yes.
The section 16 is quoted. Then, my lord, section 10.3, next page. Lordship got it. It says the Code Provident Fund so has drawn twin tests for establishment to seek exemption from the provisions of the Act. First, the establishment must be either belonging to, that is relation to section 10 B, but here we are in C. The first establishment belonging to, under control of the central or state government. The phrase belonging to would signify ownership. Our note cases here, the 10.2.3.2 Lordship will speak. Second condition, which must be fulfilled by the petitioner here. Second, the employees of such establishment should be entitled to the benefits of the contributed provident fund or old age pension fund in accordance with the scheme. Now, 10.5. With respect to the second test, it is relevant to note that the company had its own scheme, Pawan Hans Enforcement Employees Provident Fund regulation in force. The company, however, restricted its application to PF trust regulation only to the regular employees. PF trust regulations of the company were not framed by the central or state government, nor wherever applicable to the employees' companies and so. Here, they also excluded here, Pawan Hans, the contractual employees. Therefore, the second test is not applicable. Therefore, it is not covered under section 10.
No, whether they have the contractual employees or not.
They have. They have.
But that is not the subject, that is not the ground on which you have the negative.
No, that's true, Lord. That's
Then,
true. But then if
it's an order passed by you that has to resonate.
no,
on the,
what has
the
happened
ground.
is, my lord, it is an order under section
Why
7.
did you become, did the employees provident fund became clever in the year 2020?
No, my lord, section 7 capital A is a provision against which an appeal lies under section 7I. So the appellate authority which is there and the appellate forum is there. Lordship will have a look at section 7I. They can take up all these
No,
grounds.
the other all things are there. But the fact remains that you order does not speak. Because of that, because of the 4, 3, Roman 2 and 3, it is not taken into consideration. Less than
That is, and moreover, I have taken another plea, because Central Act is a prior act law. It is a subsequent. So, if it is repugnant, though I have taken the plea of repugnance, but my lord, when
but your repugnancy provision also 16.1 B or 3 specifically provides that there is an exemption.
no, my lord will kindly have a look at section 2 of the act, 2F. Employee. It says employee, lawsuit 2F. Section 2, small f.
Which
Lordship.
employed for wages in any kind of
and includes person employed through, by or through contractor. So, my lord, employee,
Understood. These are not your grounds.
true.
So-
But if it is not applicable, my lord,
no.
this is what my
No,
submission
Mr.
is.
Roy, kindly come to one aspect of the matter that yes, would they be liable to pay in addition to the CPF,
My lord,
in addition to the CPF, in respect to those regular
my lord, for regular employees, the other district could rely on. For regular employees, maybe there are two categories. For contractual, they will have to contribute.
for contractual they may have to do it, but for this they may not.
Regular.
Regular it may not. So under such circumstances, it may be EPF may be applicable in respect to that.
That's right.
But how are you imposing the entire thing on taking as a whole?
My lord, they have not given us the details of the movie. This is our own inquiry.
But that is not a part of
We
the
have-
order. This inquiry came later
So,
on.
my lord, my submission is, this is a question of fact. Lordship, my lord, will have to determine it. Therefore, lordship is not the forum to determine this question of fact.
I'm not determining that. I'm determining on the
So it
question of
is the
whether
appellate forum or
your
or my lord.
reason for passing that order is in consonance with what you are saying.
My lord, there is a provision under section 7B for review also, statutory review. Statutory review 7B, statutory appeal 7I.
You want them now to allow you to improve your order.
No, improvement there because if they are not entitled, my lord, if
Why will they
to section 16B, it is statutory provision.
you take a decision as per this? Take a decision that in respect to these things they are not entitled, for which they may not be entitled to, they are to deposit with respect to employee program for those persons, and accordingly how much they are liable to pay. But can they be twice the amount we pay? On one hand, they are paying for the regular PPF. There's no quarrel with that.
No, my lord, in face of this Pavan, well, there will be another complication in face of this decision under subsequent Pavan. My lord, whether lordship would like to give this direction, that's why my lord, the submission is, it is better, my lord, let this be decided. Let them go. Before the same authority also they can go.
I'm giving you the opportunity to decide. Who has asked you not to decide?
Afresh.
Afresh.
Okay, my lord.
That is what I'm saying.
that-
I'm setting aside this, then you decide.
In terms of the, that's the,
That is what I'm saying.
That
The
is-
reasons which you are saying,
because
I'm not setting
there has
aside.
to be material before lordship. That's why.
So therefore, I am allowing you to do it.
Lord.
But you have to do it afresh.
Oh, yes, that's
Taking
right.
into account that
That-
this is the ground which is not a part of it.
That's
So on the basis of that Govardhan, Atal and Mohinder Singh Gill,
no.
this needs to be set aside.
I cannot improve. Govardhan is clear. And Mahendra Singh Gill also. No, that's right.
That is the purpose.
That's right. No, since I said it's a question of fact to be determined.
No, no,
the
that,
statutory authority.
I'm not touching on the fact.
That's
Your submission which is there,
Mm.
the 2 and 3, 4, 3, 2 and 2, 2 and 3 is not, does not take into account
by the authority while
by the
passing.
authorities.
It
And
has
these
to be, and
people
then-
are not entitled. So there will be a factual finding which you have to do.
That's it.
You can't
no,
immediately
I
say
understand.
that you have to.
No, your lordship is absolutely. I understand. Because
So you
after all, my lord, it is when a statute provides a comprehensive provision, my lord, that it is the same authority who is true, my lord. It is not in so many words they have not decided that. Their lordship will grant with regard to.
you do it.
And if they want to submit some fresh material,
You
they can.
issue notice to him. You issue notice asking him for a hearing, and we give him a notice in terms with the allegation now. Have to put.
Lordship. And
As of
lordship
now,
is
you didn't put it. Now
absolutely.
you have to say that these do not come with it. Now you have to reply why.
Or my lord, but it's better, my lord, to go to the same authority. Same authority. Because
The instant with petition has been filed by the petition. challenging the order dated 29/5/2015, whereby the petitioner was directed to pay an amount of rupees 9 crores 46 lakhs 13,316, and further for setting aside the order dated 28/7/2015 issued by the Assistant PF Commissioner Compliance, whereby the banker of the petitioner was directed to credit the amount of rupees 9 crores 46 lakhs 13,316 within 3 days in favor of the Regional Provident Fund Commission. This court This court have heard the learned counsels appearing on behalf of the petitioner, as well as the respondent authority. A question have been raised in the instant proceeding challenging the impugned orders on the ground that the said impugned order was passed without taking note of Section 16(1)(c) of the Employees Provident Fund and Miscellaneous Provisions Act 1952, for short, the Act of 1952. In the proper perspective, inasmuch as the petitioner had framed a set of rules known as the Assam Khadi and BI Board Contributory Provident Fund Rules 1962. And the said rules provide for contributory provident fund in favor of its employee, for which the Act of 1952 could not be applied. Mr. P.K. Roy, the learned senior counsel appearing on behalf of the respondent authorities, has submitted that though the Assam Khadi and BI Board Contributory Provident Fund Rules 1962 provide for a provident fund contributory scheme, but the said scheme is not applicable to various categories of the staff of the petition, as would be apparent from a perusal of Rule 4(3) Roman 2 and Roman 3, which stipulates that the daily wages employees of the board, as well as employees whose terms of employment are governed by special contracts, would not be entitled to subscribe to the said rules. The learned counsel for the petitioner responded further, drawing the attention of this court to Section 2(1)(2)(f), wherein the definition of employee has been mentioned. Submits that employees who are appointed, employees who are employed by or through a contractor, in the work with the work of the establishment would come within the definition of an employee. And therefore, the exclusion made by the rules of 1962 in respect to those contractual employment as well as for daily wages brings the petitioner within the fold of the Act of 1952. The Learning Council further drew the attention of this court to the judgment of the Supreme Court in the case of Pawan Hans Limited and others versus Aviation Karmachari Sanghatha and others, reported in 2020, 13 SCC 506, and specifically referred to paragraph number 10.2, 10.3.1, 10.3.2, as well as 10.5. Taking into account the relevance of those the paragraphs so cited, the same are reproduced here in under. In the backdrop of the above, this court have also perused the impugned order dated 29/5/2015. A perusal of the said impugned order categorically shows that the contention of the petitioner was duly noted to the effect that in view of the rules of 1962, the petitioner would not come within the ambit of the Act of 1952. However, the finding which have been arrived at is that the establishment, that is the petitioner, finding which have been arrived at, is that the scheme, that the PF scheme of the petitioner has not been found to extend social security benefits to the employees, and such benefits as a whole are neither at par nor more beneficial than the benefit provided under the Act of 1952. The order, the impugned order, however, does not in any manner deal as to whether the rules of 1962 deal with the question that in view of clause 4.3, 4 Roman 2 and Roman 3 of the rules of 1962, there's a requirement section 16(1)(b) of the Act of 1952 would not be applicable insofar as the petitioner is concerned. Rather, the findings arrived at by the impugned order is on the comparison of the benefits. They say the finding in the on a reading of section 16(1)(c) in the opinion of this court is not in consonance with the Act of 1952. Inasmuch as a perusal of section 16(1)(c) mandates that the provisions of the Act of 1952 shall not be applicable to any other establishments set up under the central, provincial, or state act, and whose employees are entitled to the benefit of the contributory provident fund or old age pension in accordance with any scheme or rules framed under that act governing such benefits. The said provision does not deal with the question of deal with the comparative benefit in terms with the Act of 1952 or the rules or the benefits so accrued by the employees of an establishment set up by any central, provincial, or state act. Therefore, in the opinion of this court, the impugned order dated 29/5/2015 is interfered with. This court have also duly taken note of the submission of Mr. P.K. Roy, the learned senior counsel, as regards that to the effect that the rules of 1962 do not provide benefits of the contributory provident fund to daily wages as well as contractual appointees. This court have also taken note of the judgment of the Supreme Court in the case of Pawan Hans Limited and other supra. However, these aspects which have been argued by the learned counsel appearing on behalf of the respondent though seems to be attractive, but are not the basis on which the impugned order was passed. In this regard, this court finds it relevant to refer to the judgment of the Supreme Court of the Privy Court, the Supreme Court, in the case of Govardhan Das Bhanji versus Commissioner of Police, Bombay, reported in AIR 1952 SC, page 16. wherein it was duly observed that public orders made publicly has to be tested on the basis of the reasons to assign and not on the basis of affidavits filed subsequent. The said principles have also been reiterated in the judgment of the Supreme Court in the case of by the Constitution Bench of the Supreme Court in the case of Mohinder Singh Gill versus Election Commission of India, and more particularly at paragraph number 8, reported in 1978, paragraph number 8, which is reproduced here in under. Taking into account above, this court sets aside the impugned order dated 29/5/2015, as well as the consequential order dated 28/7/2015, for the reasons above mentioned. Before parting with the record, this court, however, makes it clear that the above observations and decision, the instant decision of setting aside the impugned order dated 29/5/2015, as well as the consequential order, would not preclude the respondent authorities to initiate de novo proceedings in respect to de novo proceeding against the petitioners in respect to the period for which the impugned order was passed. The said proceedings may also. It is, however, observed that if such proceedings are initiated, the same should be done so in accordance with the prescription of the law. Hey, Mr. Munir, take this. It may help you out. Kuntu. Itu tadi. Yes, Mr. Goswami. So late in the day. Yes. You are challenging some orders.
Yes, my lord.
11/9/2017.
That the conflict labor regulation abolition under 25 25 2 I so Roman 5
Page 55 or 60. Annexure 9.
there was taken,
Hmm.
was taken. With the division has without regular section and also contractual employees to contractual under next subsidiary. So, 80 without these are industry-wise considered exceptions. It is the background that initially it started from 2010 and 2010, and we are really concerned with the period from 2010 and 2020. There are two agreements in 2010, but they are divided into three groups contracted. They are called WPN 1, WPN 2, and WPN 3. So, just divide constraint set, and they will make that in respect in one or another. They have signed that they are given, and all contractual employees are getting benefits under group, including this group is now on the new. So during the currency of that settlement, and also of taking those benefits, the, the new union strength, and they claim that they have a membership of about 31,351 employees. And they initially first filed a writ for this court. Basically, idea was to have a regularization order, which ultimately was disposed of as instruction. Thereafter, 2015, they proved due to respondent number 3. They initially said that they should get the same wages and all, and then they made a claim of regularization initially. Then they converted the same thing to an application under that Rule 25, asking for same and similar wages like the contractor. That's the whole thing. It is equal pay for equal work. So that the commissioner, respondent number 2, which is the statutory authority, he first issued letters to the company reply saying that all the currency of a consideration that people are covered by that, and so listen to there is a clause in that contract that they will not raise any new demand during the currency of and then but the respondent who proceeded with that, initially he deputed a junior officer of his to go and see what can be done. That officer, we didn't get the report, but from the order, impune order, it appears submitted a report saying that it is difficult to equalize or something. Therefore, what he did, number 2 officer, he landed up at Juliaga from 3rd May to 5th May, 3rd to or 5th, in 2017, saying that he is going for a spotted. He came, visited 8 departments. All India has about 36 departments. Then he picked up 14 from contractual workers and 13 from regular workers and took their statements and then So he passes this order
Hmm.
saying that they should be given. It is not even that. Kindly see the finding at page 75. All parameters of an approach in this kind of a matter was overlooked. It's a very long order. That's it. But, but the main finding is after discussion at page 75, second paragraph. After perusal of the above statements of contract workers and permanent employees, it is a fact that there is no total similarity in the job contents of both types of workmen, but it has been established that there is similarity in the job contents of these workmen to a great extent, with a few exceptions. So he himself comes to this conclusion that the identity similarity is to certain extent, and it is not complete. That is the pre-requirement of that rule, that it must be same or similar as the regular employee. And he then goes on to say, the contract workers categorized as WCL listed 1, 2, and 3 in the soft and production test and all that, are working since long and have acquired sufficient skill and knowledge of their work. They have worked in other shops and sections also, so they are having varied work experience. They have proved their utility by helping the management in core activities of the company wherever engaged. The permanent employees may have different nomenclature so far as their designation is concerned, but they are performing almost same type of job as that of contract workers. The duty hours of the contract workers are same in comparison to permanent employees. It was also observed during the inquiry that permanent employees, although supervising the work of contracted workers, in some cases are also doing the same work as a team. And there is no differentiation in the nature of the job of these workmen. The inquiry was conducted on random sampling basis. It has also come to the notice of the authority that there are many field stations of the company where contract laborers are not performing the same job as being done by the permanent employees. So there cannot be any comparison in respect of the job contents of both types of workmen engaged in this stability station. As such, the justice demands that the contract workers in the category of the one performing the job of cleaner and helper in shops and sections like production, oil production, SS production, gas, field communication, engineering, materials, civil, and all that, and figuring in the list of the union should be given to this 27,629 towards wages which they were getting. He is now adding 5,000 more to that, plus 5,000 on account of one-time fixation benefits per month. It's a per month he should do that for 5,000 one category, 2,000 one category, and ultimately with the third category, he is giving a increase of 10,000. Although he doesn't give that, I mean, conclude this on account of one-time fixation benefits per month. So far as contract workers in the category of WSTL 2 performing the job of cleaner and helper in the above top sections figuring in the claimed list of the union are concerned, they should be given 27,629 towards wages plus 3,000 as one-time fixation benefit per month. The contract workers in the category of WCL list 3 engaged as cleaner and helper in the top sections whose same figure in the list of the union should be given rupees 27,629
So they were already getting 27,000.
is not the third category. If your lordship kindly have a look at page 58, 59, the lordship will see the position.
The third category, there is no increase.
No. So it has gone by 10,000. I'll show it. Your lordship will kindly see at page 58, 59. The chart is given below. If your lordship kindly have a look at page 59, 58. This is for the regular employees, page 58.
So here, if we come to this with page 80 of the order, 80 of the order,
Yes,
what he has done
yes.
for the WCL 1 and 2,
Yes.
he has increased by 3,000 plus 5,000 and for
5,000
1.
and 3,000.
Yes.
And
Now,
for
however, for grade
for
1 at page
grade
58,
3, kindly see at page 59. That will make the position clear.
it's 26,597 for grade listed 1.
Yes, kindly see at page 59. Wages being paid to listed WCL 1, 2, and 3, and other allowances as on date. And if your lordship see the category listed 3,
16,000.
16,998.58. That is what they were getting.
And he increased
And-
by 10,000.
And he has increased by 10,000, which your lordships will find at page 80.
81 is there.
Yes,
WCL 3
Yes,
and
yes,
WCL 3.
yes.
8, 6 and 9.
correct. Right. He has given the figure 27,629, and only thing is, they were drawing 16,998.25. So the addition is really to the extent of 10,000 as your lordship said.
What is the difference between WCL 1, 2, and 3?
The difference is that three different kinds. So the agreement, first agreement was with regard to WCL 1.
Who are those category persons?
There are different categories,
Because if we see, kindly see page 59.
15.
For WCL 1,
Yes.
the dearness allowance is 114%.
WCL 1, the basic is 10,000, then ultimately total amount is 26,597.96.
Understood. But you see, for 1 and 2,
And
it is
2 also,
114%, whereas for 3 is 48%.
so far as
3 is concerned, it is 48.
the amount drawn by listed 1 is 26,596,796 to 25,565.12, and the third was 16,998.58.
Now, the reason is more particularly in view of serial number 2, because of the dearness allowance on top. If you see,
Yes.
1 is basic. Basic remains almost the same.
Yes.
1 is only WCL 1 is the 10682. Other 2 and 3 is 10267 and 10267. But if you see the next one, the dearness allowances is 114% for 1 and 2.
Yes.
Whereas for 3, it is 48.55%. And therefore, it is 49,885. And this makes the entire change.
No, DNS allowance is it's at 114.98 on
For
basic,
list 1 and list
listed 1 and listed 2, and 48% 65 on basic 2, 3.
So this
So
makes
different.
the entire difference.
different. And therefore, the amounts are vary. Your lordship see the amount depending on the basic pay, because if the fee is less than the other two groups, therefore the amount is less. So far they are concerned.
Maybe they have joined later on or
That
something.
is so far 2 and 3 are concerned. It is without on a basis of 3,000 uh, 20 or 2,000. 2,000 and he is post 2,000. So the period may be different for each of these groups. But the problem is that so far these allowances are concerned, the total amount so far grade 3 is concerned 16,998. But as your lordship has seen at page 80, this has been now raised to
27,000.
27.
They must have done it on the basis of page 58.
The basis is very difficult to understand from the order.
Because that is the
Because it
amount
is
on
like a
which
per
he has
month,
done it.
He is giving 5,000, 3,000, and then so far as this third category is concerned, and he is giving from 16,998, it goes right up to 27,000.
This has some similarity with page 58.
This is 58 is regular.
Yes, and interestingly, the
Yes.
basic of the regular employee is 9,300.
Yes.
Whereas the basic of WCL 1, 2, and 3 is 10,000 something.
This is grade 1. This is the starting point. So far the regular is. You have 9 grades. It starts with grade 1. It's the first entry point. And then it goes on till 9. So this is how it is structured. And therefore, this is, this is so far as the page 58 is for grade 1 regular. This is the regular workman who you get.
Here the basic is different.
Basic is different.
Basic is less.
Yes.
Is 9,300
Yes.
for grade 1.
Yes.
Whereas, and on the basis of which it comes to 27,629.
Correct.
Whereas for WCL 1, 2, and 3, the
Yes.
basic is 10,682.
Yes.
10,267 and 10,260. So here the basic is more.
Yes.
So the question out here mainly revolves around the
Great,
coefficients of the dearness allowance.
DNS allowance is pretty basic.
Yes.
And the amount percent.
Yes.
Therefore, there is a difference. 120 or the difference that is acceptable. There is no problem with that. But what he has done so far, the district 3 is concerned. Your lordship sees they get 16,998. And now what is given to them is at page 80.
Mr. Goswami, the question therefore is the question of on the dearness allowance, not on the basic.
So the basic also is different.
No, understood.
Huh.
Whatever may be. But what he has done, he has given this 27,000
Yes.
on the basis of grade 1.
Yes.
Now, grade 1 basic is 9,300 and the dearness allowance is 117%. Okay. Now, for WCL 1, 2, and 3, one is 10,682
Yes.
and the others is 10,267. Now, the question is why the difference out there which has come out is because of putting out there the dearness allowance of 114% in WCL 1 and 2, whereas for others it is 44%. Now, these what do you call, the basic, the dearness allowance, why it has been put out there? is the question, which I don't think he has taken note of in the order.
Doesn't look.
Because you see, is I
Because
could not,
He's
the
giving
question,
lump sum. Sir.
yes, the
He's
question
giving
of
lump sum,
parity in pay,
and from 10,000, 16,998 to which the tree, listed tree was drawing at page 76, your lordship finds he is giving 27,629.
the parity in pay has to be, if we say that everything is okay also, can it be taken note of on the basis of the basic pay, or is it to be taken on the also on the question of the dearness allowance?
True,
Because the basic remains the same.
true, but this is concerning the contract laborer, three categories, divided because of different reasons. And their basics are different. And therefore, the total amounts are different. And possibly the period of service may be less or more. But so far as this grant is concerned, brother, he is increasing 5-3, and he is not specifying any amount for the listed tree, but from he says only that they should get 27,629, which will mean, below, that they were drawing 16,998, and it is being increased to 27,000 and odd. So it's basically, as your lordship has pointed out, it's about 10,000 increase. So 5, 3, and 10,000. So there is no explanation as to why this 5,000 is the amount he has chosen, or 3,000 why has he chosen, or 10,000 why has.
Where is the memorandum of settlement in respect to this, which is given at Annexure Roman 4,
Yes.
page 59? Where is
Page
the memorandum
31
of
is one.
page?
Page 31 is the settlement dated.
No, this is for the amount is 4,800. I'm on the present one of
Of present,
10,000. Because there you get some touch on the dearness allowance. Where's where's the one by which it has been increased from this 10,267, which is the basic has been done?
Then the other one is at page 36.
But no, that is also does not take care of that aspect. There has to be some memorandum of settlement on the basis of page 59. Yes, 28/5/2013. There is the 28/5.
Page 36. Page 36. Second. Annex 2.
Yes.
Page 30. Page 30. Take it.
But if we come to page 37,
Yes.
here the basic pay has been put at 9,300. But how does this amount come to 10267?
This is period of 28/5/13.
Hmm.
And it is for listed 2 and 3. This settlement. The first settlement at page 31 is 24, listed 1. Now, of course, period over a period of time, that it used to 1. But at that time, period, because at 3 different groups were there, the first one at page 31 is only for the W1, and then 2 and 3 is at page 36, which is of 28/5/30. The first one is dated 11/8/2010. That is applicable only to WC at 1. And this comes under for both 2 and 3, 28, 5, 30. So it was to be enforced from 1712 to 3620. And the first one, 1110 to 311290.
This memorandum of settlement, the respondent number 3 was a party.
No, they have come much after because they appeared, the parties were different because you recognized unions are party to it and they are different. This the new union.
So they came out there.
They came out
They've
there
taken
and
out
claimed-
these people out
and
there.
possibly they are claiming 1351 of these people who are drawing without their benefit under this scheme, under this settlement. So that is one aspect. The other aspect is, the learned, the component number two, the lordships are fully aware of those parameters. The process of selection in one case, it is open to the other is the contractual relations that the contractual is applied, and they are engaged. So it's a inferior in so far as the responsibility or the nature of function. These are all parameters to be applied and to find out whether the same pay can be given, because it's a class of contract labor and they're aspiring for the regular selection, regular wages of the regular selected, openly going to that selection process. Therefore, you are not aware of those parameters. First, the nature of contractual or scope, then the nature of job, then the nature of responsibility, and all those parameters are there. So unfortunately, because this looks like a virtual Farman Miller, he says that I give 5,000 to one, 3,000 to the other, and increases 10,000 so far as that third group. So without any discussion on the relevant aspects which are needed to be gone into, and for which the materials should have been collected by him.
Mr. Gustami,
Yes.
let us do one thing.
Yes.
You see page 54
Yes.
of your petition.
Yes.
Kindly bring on record the entire document
54.
along with its enclosures. Then we can get a fair idea. Because this is your representation.
This is
And-
our reply.
And yes, or whatever may be, but that categorically says about these page 58 and 59.
Yes. Yes.
Yes. So if you bring on record the entire document, we can get a good idea on that. Because you see what has happened, the earlier two memorandum of settlement
Yes.
puts the figure at 9,300 as the basic. However, at page 59, we see the basic to be 10642 or 682 and 10267. And 9,300 remains the basic for the grade 1. 9,300 is the basic for the grade 1. But for WCL 1, 2 and 3, the basic is different. Here there are various enclosures which have been made in this particular document, which have been the following annexure, kindly page 56 if you
57,
see.
Milord.
The following annexures are enclosed. Copies of the labor license issued by the contractor engaging so and so, pay scale of tradesmen with so and so, wages being paid to so and so, listed so and so. However, the document only of 2 and 3, annexure 2 and 3 are there at page 58 and 59. However, the documented 1, 4 and 5 are not part of it. I think for a better understanding of this matter,
No, sir, always.
yes,
We can
kindly
the
file an
details.
additional affidavit bringing on.
I
Yes, I think that is a better option.
Yes,
To
yes,
file, bring on-
took it.
will-
Yes, yes. Wait, your lord. put it out at page
The entire annexure 8 along with its enclosures. Upon hearing the matter,
3617.
this court finds it pertinent to note that to take note of that the document dated 3/6/2017, which was submitted by the petition, has certain relevance. However, the entire document along with the document along with all its enclosures have not been made a part of the petition. The petitioner is directed to bring on record the entire document enclosed along with its enclosures by filing an additional affidavit. This the matter again on 15th of February. Mr. Gustami, you will be there? 15th of February.
I hope so.
15th of February.
I don't know, but I hope.
15th of
But if
February.
I am not here because I
Yes.
trouble your lordship. I tell him
15th
because
of
I
February.
have to go for an operation. Therefore, I am not sure about the date. Therefore, I am making it a little flexible.
Okay, we'll consider.
We can sit on that date,
On
but in
15th
case
of
I am
February.
not here, because your lordship will accommodate.
15th of February. And the affidavit, the additional affidavit, we filed by 12th of February.
The 5th of February, but I have some difficulty.
Then I will have it on 5th of March.
Yes.
The affidavit we filed by, I'm not there from 19th to 1st.
Right.
I'm not there. So I'm picking it on 5th of March.
Yes.
Can I call the
Yes.
But the thing seems to be something to do with the dearness, which have not been taken note of by them. The basic remains the same. It is the dearness which makes the difference. And dearness makes everything different because the WCL 3 basic remains the same. It is the dearness which is 44% for which he gets 16,000.
Will explain.
Plus the other allowances.
Other
Other
allowance is
allowances
there.
are
Other
also
allowance is there, but I could look into it. Yes, it will make hardly 1,000 difference out there, not much. Because it is otherwise 27,200, 900, and here it's 26,900. So 1,000. The other allowances is there for some canteen allowance and all these allowances are there. But that is okay. But the basic is the question. Basic remains the same for the WCL, and here the basic is less. But here the dearness which has been given is 117%. Here for WCL 1 and 2 it is given 114.
14.
And for 2, 3 only 44. Now the reason why this is being given is the catch.
We'll take instruction on.
Because the parity and because normally when you are going into the parity of pay, you don't look into the question of dearness. You see on the basis of the basic. And then the dearness is worked out. But why the dearness is given so less in
Well,
respect to 3?
Learned Commissioner has gone into the aspect of total emolument paid.
That's right.
What is getting? Permanent workman, what he is getting, and the WCL what is getting.
Understood, but whatever may be, normally when equal pay to equal work is looked into in various judgments, it is done on the basis of the basic, and thereupon everything revolves. Once you fix the basic, everything evolves. But why there is a difference in the dearness? For 3 is 44 and
Yes,
this
yes.
is 114, whereas for grade 1 out there it's 107. This is the catch on which we have to understand.